Okay, this February 4th, 2026 hearing of the Board of Zoning Appeals in Sykesville is now in session. We're going to hold this hearing pursuant to section 180-105 of the Sykesville zoning ordinance. The order that will conduct this hearing is: one, our applicant will put on its case. Then the town staff will discuss their report and responses and recommendation. And number three, anyone in opposition to this appeals application will also be allowed to testify. And then four, anyone who has not yet testified but wishes to do so will then be allowed to speak. And number five, the applicant's attorney, Mr. Bowersox here, will be allowed up to 10 minutes for rebuttal and a closing statement if he wishes to do so. All those who are going to testify at this will be sworn in by Carrie, our town clerk. And at that point, we have a slight change in what the agenda was for this evening with regard to case number 2025-02. Mr. Bowersox, you can explain what your request was for that.
Thank you, Mr. Chairman. Good evening, everyone.
Yes.
It is, okay. Good evening. I hope I keep these numbers straight. There's three cases that have been brought to you by Warfield Companies and Thrive between the two entities. Warfield appealed a planning commission determination in what I believe is case number 2025-02. Is that?
Yep.
So far, so good.
That's the appeal of the planning commission decision.
Correct. You have already heard Warfield's request for variance in case 2025-03.
Correct.
And that's pending before you. The issues in that variance still yet to be decided, once resolved, could influence and inform, probably is more accurate, the manner in which the applicant Warfield Companies may elect to proceed in that case ultimately. Instead of going through that case tonight, we're asking for that case to be continued to a later date because depending on what you decide in the variance,
Yes.
until we know where we are with that, it seems like an investment of a lot of time, not just ours, but yours, and resources to hear it. We're not pulling it, we're not withdrawing it, we're asking that it be continued to make certain that what is germane to that issue on appeal is presented as cleanly as it can be presented. We are asking to move forward with Thrive's appeal of the zoning administrator, town manager's decision in case 2025-04, which is an appeal that was filed by Thrive. That is not as intertwined, so to speak, with the pending variance as case 2025-02. And we feel we can move it forward tonight and at least hopefully get some disposition of that issue out of the way. So that's what a request is.
Okay.
Well, I think
add
it's
anything to
appropriate for the board to make a motion and to vote on
Yes.
the request for continuance at this point?
Yeah, we don't have a select date at this point, but we can go,
No, I
we
think
can,
we can deal with that later,
we,
later in the.
if you're okay with that. So I would make a motion that we, keep case number 2025-04, put that on the continuance, pick up at a,
The O2, I'm sorry, Chairman, O2.
I'm sorry, 02, you're correct, amend that. Case number 2025-02, to continue that to a future date, after 2025-03 is decided. I hear a second?
Second.
Okay, all those in favor? Oh, good, that motion is carried. We shall do. We want to deal with dates possibly later, because we have several dates to deal with.
Yeah, we'll deal after the O4 hearing, I think.
Yeah, yeah, okay. So for case number 2025-04, I would say who's going to be testifying on that, right here?
Principally, it's going to be Sean Davis,
Okay,
of Morris Ritchie and Associates.
anybody who's going to be testifying right now, would Carrie will swear you in?
Yes, sir.
Okay.
Okay.
We may have others depending on how the
Okay.
testimony goes in the proceedings. You all right?
Yeah, I'm trying to stand up. I think it's the appropriate thing to do.
Stretch?
As an individual who wishes to testify in case 2025-04, we can do them individually.
Okay.
All right.
In case 2025-04, please stand and raise your right hand. Do you solemnly swear that the testimony you are about to give at this hearing shall be the truth and nothing but the truth?
I do.
All right. Then go ahead and proceed to present your case, please.
Okay,
Mr. Chairman?
Yes.
We gotta read the, I guess the opening statement into the record, just to verify the case.
Oh, all right, we'll go ahead and do that. I had that in another, go ahead.
Oh, yeah.
Sorry.
So case number 2025-04, request for an appeal of the town manager and enforcement of the plan amendment process established in the Plan Employment Center zoning district, was properly advertised twice through the Carroll County Times, with one being at least 15 days prior to today's meeting. The case was properly posted with signage on the subject property, and all adjoining neighbors were notified via certified mail.
All right, thank you. Hey, any other input at the, before we
That's it for ours.
go back to our agenda then?
so initially, I would like to move into the record materials that I believe you're familiar with. One would be the application for appeal that was filed in this case. The August 28, 2025 letter of Mr. Cosentini as town manager, zoning administrator, making his determination. And
Excuse me, Mr. Sykes, what date was that on the?
August 28th, 2025, I believe.
Right.
Yes, right.
And there is a staff report that was also circulated. I don't know if that's in the package that they have. For the sake of completeness, that is something we would like to also have incorporated in the record. All.
The staff report, to clarify, is that the one October 29th?
Yes,
Yes, that's correct.
All right,
that's the one we have seen.
thanks. All right. So those are going into the record. All right, for 2025-04. Yes, sir. All right.
Okay. Good evening. I'm here, I'm going to present Mr. Davis as principally the witness on behalf of the applicant appellant here, Thrive. Mr. Hobson One of the principals in the Thrive entity is here tonight as well, as are representatives from Warfield Companies, the owners of the property. Mr. Davis, could you let us know your name and address?
Sean Davis, I'm a principal with Morris Ritchie Associates. My address is 1414 Key Highway, Baltimore 21230.
All right. And what do you do for a living?
I'm a planner and a landscape architect.
All right, and you're here tonight testifying on behalf of the appellant Thrive, correct?
Correct.
Are you familiar with their appeal to the Board of Zoning Appeals?
I am.
You're familiar with the subject matter?
I am.
I'm going to show you something I'm going to distribute.
Ms. Barsok, can I just ask a question? Are you going to be presenting Mr. Davis as an expert? Or
Yes.
simply as a fact witness on this?
Well, to the extent I ask him for his opinion and expertise that's implicated, I would like to do that. And my intention is to try to streamline the qualification in light of his prior recognition as an expert by this board in, I believe it was October.
Okay, so I just want to make sure that's clear that he's being
Yes.
presented as an expert, and he was qualified as an expert in the October hearing, if I recall,
Yes.
and so that will carry over, and I think I just want to make sure we're clear.
Could I ask him to identify the subject matter on which he has an expertise for the record, because it conceivably could be different.
No, Mr. Davis has a law degree, but he's not testifying, he's not going to give a legal opinion. I have him here tonight for his expertise, if needed, in land planning, design, the zoning, and regulatory approval. I do have, for the record, a copy of his CV.
Might not hurt to put that into the record,
Okay.
just for, so we'll
No,
have
no.
it.
How many? Just the
Yeah,
one?
just give it to Karen,
Yes.
yeah, that's fine.
Yes.
Thank you. All right. One other thing before I go further with Mr. Davis's testimony, we would like to move into the record of the proceedings prior in case 2025-01, I believe it was, which was the conditional use application of Thrive for this site that is the subject matter of our appeal tonight.
Was that the special exception case?
Yes.
Conditional
yes,
use.
Conditional use,
My apologies.
Conditional use,
Yeah.
yes,
yes.
last spring. Mr. Davis, are you familiar with the applicant's conditional use application?
I am.
From April 25?
Yes,
All right, you were not present for that, though, were you?
I was not.
Okay. Do you know that request is for an assisted living facility on parcel B at Warfield?
Yes,
Do you know, was that a unanimous decision to approve that by the board?
yes, according to the minutes.
All right. Had the planning commission previously reviewed Thrive's assisted living proposal?
Prior to the BZA's hearing, yes,
All right. And did you know if they made a recommendation to the board?
yes,
And was that favorable?
it was.
All right. So are you familiar with parcel B and Warfield generally?
Yes,
And by Warfield, I'm talking about the Warfield property and the planned employment campus center, the PEC plan.
yes,
What Thrive submitted an application. Thrive has had conversation and correspondence with Mr. Cosentini about their desire to move forward and begin processing a individual site plan for that assisted living facility. Are you aware of that?
yes,
All right. Have you participated in other reviews for individual parcels development in Moorfield?
Yes.
subsequent to the PEC plan, concept plan, and preliminary plan approval?
Yes,
Those reviews generally, are they joint reviews by the county Bureau of Development Review and the town staff?
yes, they are.
All right. And are you familiar with Mr. Cosentini's August 28, 2025 letter and determination about the manner in which that individual site plan is to be handled?
I am.
All right. In that letter, there's a reference to a PEC approval process set forth in Town Code 180-144. Are you familiar with that?
I am.
Does the PEC code also provide for preparation of a pattern book to
It
guide
does.
development?
It does.
All right. Would that be section 180-143?
Yes.
All right. Is there a specific site development process that's set forth for improvements of individual sites in the Warfield PEC project in the pattern book for Warfield?
There is.
So a pattern book has been approved.
The pattern book was approved as part of the overall PEC preliminary plan process.
All right. Mr. Cosentini, in his August 28 letter, refers to processes for the PEC. But is that the same process that's set forth in the pattern book for individual site development plans?
There are two, it's different.
All
There are
right,
two
can you
different-
explain that to the board?
So the way it was set up through the zoning ordinance was that the overall development of Warfield went through a three-step process. There was the PEC, what we call the PEC concept plan, which was a bubble diagram, for lack of a better term. And then there was the PEC preliminary plan for the entire project. And then after that, each individual parcel would come in for their final plans, if you will. That is referred to not in the zoning code, but in the pattern book, the process for those individual site plans or subdivision approvals was established in the pattern book.
All right. And were you involved in the Warfield project at the time the pattern book was approved?
Yeah, I wrote the pattern book.
Okay. How long have you been involved with the Warfield project? I know you provided this testimony back in this, before, but if you could reiterate.
With the applicant, with the Warfield companies since 2015, but with Warfield since the town's design charrette, God, I can't remember, in the late 1990s, early 2000.
Okay, but a pattern book was prepared. Was it adopted?
It was.
All right. I'm gonna show you something that I'm gonna have marked as exhibit number 2. I believe the CV was number 1. And ask if you can identify what this is.
This is the approved pattern book dated October 16th, 2017. It was version 6.
Now, is that the entire pattern book?
No.
All right. Can you explain what this is? Can you tell from what you're saying?
If you turn to the third page in the handout, this is the introduction section of the pattern book.
Okay, now, you mentioned before a specific process for individual site plan approval.
Yes.
Can you tell the board members where that is?
On page 2,
Page number 2.
Page number 2, introduction, page 2.
Now, can you help us understand what this means and how this process is supposed to work?
So,
Objection, the document speaks for itself.
I'd say continue, objections noted, but continue on with that. Okay.
sorry.
Go.
So the process that was laid out in the pattern book is that we had been through, if you look, it's the bottom half of this page 2, under process. Every applicant that proposes development within Warfield will follow the process shown below, ensuring the smoothest and most expedient approvals possible. The process begins with an initial discussion with the town staff and consultant team to discuss the proposal, then continues to preliminary and final plan engineering submissions that will be reviewed and approved by the Historic District Commission and Planning Commission concurrently before proceeding to the next stage of approvals. The first box that you see there is the PEC concept plan. That was approved. The second box was the PEC preliminary plan and development pattern book, which were approved. From that point, we were then going into individual sites. We first went into the individual parcel ENF subdivision process, and subsequently we went into what was called Building F in Parcel D, which were individual site submissions.
Now, it's just for clarification or the board's benefit, parcel ENF was the Parkside
Is the
project,
That's
correct?
correct. It's the Parkside neighborhood.
Okay.
So we had been through the PEC concept plan, gotten that approved, been through the PEC preliminary plan, gotten that approved, and now we were going into the individual parcels. And the process is clearly stipulated here. You have a discussion with the staff and the consultant team, and then you have a discussion with the Historic District Commission and the Planning Commission, and then you go into the preliminary plan submission process with the staff and the HDC and the Planning Commission, and then you go through the final site plan or subdivision process. So we're calling these individual site preliminary plans and final plans, which is what we did for both Parkside and Building F and Parcel D.
May I ask a question here?
Sure.
Mr. Davis, is and this is really for my edification, it says preliminary plan, is that the subdivision or is that the preliminary, the next steps up in the concept plan?
Which preliminary plan are you referring
Well,
to?
that's what I'm trying to get
So
clarification on.
okay, there are kind of two processes. The first process dealt with the overall property. Okay, that was the PEC concept plan and
Right.
the PEC preliminary engineering plan. Okay,
All right, well, that's important. That's not a preliminary plan of subdivision, it's a preliminary engineering plan.
it's a preliminary engineering plan.
Okay.
Correct, and that's for the entire 90 acres.
Right.
Both of those were for the entire 90 acres. And then we assumed at that time that what would happen is individual parcels would come in for their detailed engineering and planning approval. And that they would go through a preliminary approval process, either preliminary site plan or preliminary subdivision plan. And then they would go into a final site plan or subdivision plan for that parcel and only for that parcel.
But I guess question on that, and that is, would not any parcel need to be subdivided to allow any structures on that property? So you're saying either preliminary plan, a subdivision, or a site plan, wouldn't it have to be both?
So the PEC preliminary plan had subdivided the property out into a series of parcels.
Oh, it did. I understand the parcels. So you're saying that's already been accommodated through the overall,
Through the PEC preliminary plan.
okay.
And now we're coming in for parcel B
Okay.
in this particular
The
instance.
site plan approvals.
The site plan for parcel B. Parcels
That's a
E and
commercial.
F, the Parkside, was a preliminary subdivision plan.
Right.
And then a final subdivision plan.
Okay.
So you have site plans when there's no subdivision involved. And then you have obviously subdivision when you're further subdividing an individual parcel, which is what happened with Parkside. Yes.
Question, Sean. In the preliminary plan, when you go from preliminary plan to then parcels, the parcels include common areas and roads and through roads and streets?
Yes, as they did with Parkside. So when we went in, the PEC preliminary plan had laid out an overall site plan and some general engineering and stormwater management for parcels E and F Parkside. And then we came in with the preliminary subdivision plan for that parcel, which clearly delineated the common open spaces, the roads, all of the detailed stormwater management facilities, a variety of, it's taking, for lack of a better term, it's taking engineering from 25% at the PEC preliminary stage for the overall development down to 50% for the preliminary subdivision and then 100% for the final subdivision. So it's just an evolution of the approval process from something more general, i.e. the PEC preliminary plan, to something more specific. Now we're just dealing with, parcel B, the site plan for parcel B. And so we're getting into much greater engineering.
I guess maybe I didn't make it clear. I understand that within the E and F, all the roads and streets therein were included in those plans. I'm talking about the main road coming in from 32, the traffic circle, and the main road going up through past all the parcels, the main streets that go to the back of the plot, the back of the area, if you will.
Right,
Yes.
so Warfield Avenue continued from the
Correct.
roundabout all the way over to the.
Those aren't
Park.
changed by the individual parcel developments, are they? They're not, the alignments, the locations, is that changed?
Well, in particular in building F parcel D, we did modify what was proposed within the Warfield Avenue right-of-way, public right-of-way, for the specific site plan for building F of parcel D, which was different from what was approved at the PEC preliminary plan. So the actual right-of-way did not necessarily change, the actual road right-of-way
The
did not
alignment
change.
didn't change,
But what happens within that right-of-way was modified.
such as
We added parking. We added additional parking on Warfield Avenue.
parallel parking,
Actually, it was angled parking.
angle park. Was that an expansion of the width of the street?
No, the right-of-way did not change.
So you detracted from the width to assign it to parallel parking,
The perpendicular, it was angled parking.
angle parking.
That's correct. And that modification happened after the PEC preliminary plan was done, and we were doing the detailed design and engineering for the building F site plan.
And how was that handled in terms of the approval, as terms of the preliminary plan?
So we submitted a preliminary plan to the Planning Commission, and it was reviewed, and it was approved for preliminary, and we went forward into final engineering, and we got all of the county comments on stormwater management, on utilities and whatnot, and that was also approved by the Planning Commission. So we have final site plan approval for Building F in Parcel D.
So you went back and got the planning commission and the county and all that approval. You redid the preliminary plan too.
No,
You had to put the parking in,
no, we did not.
okay. But it was
Again,
presented
remember
to
this-
them.
And I know this gets confusing, I'm trying to make it as simple. There's the PEC preliminary plan for the overall, okay? That has not been modified since it was approved.
Okay,
We made modifications to that, what was shown in the PEC preliminary plan for the overall, along Warfield Avenue, for Building F Parcel D, as part of the preliminary site plan for Building F Parcel D.
Can you explain, if I may, how that change came about?
So the county, as part of the detailed engineering process for Building F, wanted additional stormwater management for that building. During the PEC preliminary plan, the stormwater management was very conceptual.
yeah, let me get my, in building F, you
Yes.
mean in parcel F?
In Parcel D. It's
Parcel
the
D.
existing, you know where Nexion is? Okay, it's the
Okay.
building, if you're standing
I got
on
it.
Warfield Avenue and you're looking at Nexion, It's the building immediately to the left.
Yes,
That's building F,
okay.
okay?
This one.
So we had a proposal to renovate, to rehabilitate that building, to add parking and a variety of other things, and we went forward with that specific site plan.
Okay.
Okay, so the changes that we made after the PEC preliminary plan was approved as part of the Building F preliminary site plan and final site plan approval, we modified the parking pretty significantly. There was actually 2 bays of parking that were coming through that parcel as shown on the PEC preliminary plan, but because we needed to add some additional stormwater management as required by the county, we changed that and became a single bay of parking through that. And because of the parking that we lost by adding those stormwater management facilities, we extended the entrance modified the entrance for Building F from what was shown on the PEC preliminary plan, the overall, on that specific site plan, much closer to Building W, which is further down the road. Again, you have Nexion, then you have Building F, then you have the W building. So we added the additional parking within the Warfield Avenue to compensate for the parking that was lost within the individual site of Building F.
Okay.
On the opposite side of the right of way, is that correct?
That's
Okay.
correct.
Sean, hi, man.
Please.
Forgive me, I want to get this terminology straight. I
That's
think it's
confusing.
really critical to what we're talking about here. I'm familiar with, when I hear the term preliminary plan, to me, it means a preliminary plan of subdivision. Now, there could also be, I understand, a preliminary site plan.
Mhm.
I understand, very different. You're talking about the preliminary plan for the PEC, the entire development. Was the entire development subdivided before you went into individual parcels?
Yes.
In the subdivision, then, can I assume that it was what I see on this plan, which shows parcels A, B, C, D, E, F, and then the Carrie Dorsey Park?
Correct.
Which plan is
let me-
that?
And I should clarify, I'm looking at what is called concept plan. And that, would you consider that to be the initial, was that property subdivided as such? In other words, when you show parcels that are denominated with the letters we have here,
Mhm.
A through F, excuse me, or A through G, sorry. They were formally subdivided, recorded among the land records of Carroll County, is that correct? Okay. Then we talked about individual parcels. When you did this initial preliminary plan, I guess in, let's say, final, it was a record plat eventually, correct?
Yes, it was actually recorded long ago by Wilson T. Ballard.
Okay.
This is PEC 1 down in the corner?
Yes.
PEC
PEC
-1.
one, it's a concept plan, make sure I'm clear.
Can I actually look at that a little bit more?
This
Can
is,
we designate it somehow for the record? 'Cause that-
yeah, I wanna get you what, I'll make sure.
We'll make sure
what
we're
I'm
using the
dealing with
correct
is the
drawing.
Correct plan.
This was the map where, actually, the case had just got continued. This was one of the
Okay,
exhibits. in that.
for O2.
I just want to make sure we're using the right drawing.
Yeah, absolutely.
Looking at the right. You got the big one.
You got the same one you have.
I don't know that I have the big one.
Well, no, but I mean,
Yeah. If it's PEC 1, yeah, that's it. Dated, I can't read the date. Microfont.
9/2/2025.
I need a magnifying glass.
It says
Oh, I have this one.
Yeah, it's like,
I know I prepared this point.
What's the date on that one?
I don't know, can you read that?
Let me see.
Because this was the third.
No.
If Jim, I can maybe offer a suggestion, maybe we refer to the map that's in the pattern book, because that designates parcels and
Okay.
Yeah, it's interesting because I don't know that, I personally don't know that we've ever submitted this plan
Well, I just want to find out that there was a plan that we talked about, as the concept plan that everybody agrees is the approved concept plan. Start with that. And I'm glad we're going through this because I want to make sure we're dealing with the correct plan.
This is the one you submitted with 2025, case 03, the variances.
So Joe, there's one in here that is,
Yeah.
Yes, it's on page 13.
Page
Page
what?
13.
Page 13 of the pattern book.
So that would be-
I don't have page
So we're
13.
clear then. That document that was taken out of the
13,
package
14.
for the matter that's been continued,
Right.
we're not gonna refer to it, and it may or may not have been submitted in error.
I can say I never formally submitted it. Mr. Bauer thought it was included as part of the appeal.
Yeah, I don't have page
Can't
13.
recall.
We found the date already on there for you, just so you have it, that one.
Right, we didn't steal
He
it
looked
from
up
your
the date.
computer,
I'm
so.
already
As far as I
on
know.
there for you.
If it's PEC-1, it's
So I
September 2nd.
just,
That's a good point.
Yep,
I mean-
25.
Yeah.
2 or
Page-
7.
Let's.
We need to
let's
use
get-
the correct,
Yeah, here.
25.
Dr. Woodsy.
Can I make a suggestion?
Yes.
There is an
Objection.
approved PEC concept.
That's the date.
Do you have a copy of that?
Okay. This is the approved PEC concept plan.
Can we submit that into the record?
Well, it's got my notes on it, so I prefer not.
I think there's one on the town website.
It's
Can you-
consistent with the one-
can you project one on the
I have an
screen?
electronic version of it, or we can, I thought we used to have boards here, but maybe they're gone.
I see on pages 13 and 14 of the pattern book, it says site planning, concept plan. Is that in fact the approved concept plan?
Oh, he's got the whole package.
No, that's the approved preliminary, the PEC preliminary.
Okay, let's start with that then. We could agree.
We can all agree that what is shown in the pattern book on that illustration right there
Alright.
is the approved PEC preliminary.
what page is that
Is
illustration?
Is that
13 and
page
14.
part of what
We
you
don't
We don't
said?
have.
I know, this is on the, I got a full book.
Probably not.
You mean in the portion
In
of,
the X, right, in this, otherwise we
I don't
have to
think-
get it into evidence.
I don't think it was in here.
I don't think it was either.
Electronic copy.
This stops at
There,
page.
the clerk is, pulling up a copy of the preliminary plan online. And I would suggest, Mr. Chair, that pattern plan, sorry. I would suggest, Mr. Chair, that we collectively agree that that page is going to be added to this exhibit that the applicant is putting in. And that after this hearing, a paper copy will be printed and physically attached to the exhibit. Does that meet with your approval?
Yes.
But
Does that work for everybody?
Just to
Sounds
clarify, we're talking about pages 13 and 14 in the pattern book.
But
That one is 13.
Because it begins on 13 and then it continues on.
no, no.
Let me just validate in my pattern book.
May I, at this point, offer
Yes.
Exhibit 2? He's identified it and he's talked about it in his testimony. I'm not sure I've formally moved
Here
it
we go.
in.
Is that the same,
It's the same thing.
Steve, as in,
It's
that's
versions-
13, that's pages 13 and 14?
It's pages 13 and 14 in the approved
approved-
October 16, 2017, version 6 pattern book.
Right.
It's everything that you're seeing there. It was just, we put it in the centerfold.
All right, so when we refer to the,
I don't have that, yeah.
when we refer to the preliminary plan, how would you?
PEC
The
preliminary.
PEC preliminary plan, that would be pages 13 and 14 of the approved pattern book.
Correct. And that those parcels that are shown on the PEC preliminary plan were legally subdivided. And that subdivision occurred well before, I mean, that was when the town owned the property and
Yeah.
Wilson T. Ballard was working on the plan. That subdivision was effectuated then.
All right, so this is, what you're saying is that when, for example, in parcels E and F, which you refer to as Parkside it's the residential development that has currently actually been built. Each of the separate lots, each of these townhouse lots have been recorded now in the land records.
They have been through the preliminary and final subdivision process that happened after the overall PEC preliminary plan was approved.
All right, so, let's get our terminology straight again. I wanna make sure, because we're batting around the words preliminary plan, but they seem to have two different meanings.
The biggest context that I could say is whenever I say PEC preliminary plan or PEC concept plan, it deals with the overall property, all
Okay.
90 acres.
So it's not
Then
a
when I
subdivision
deal-
plan.
Correct.
Right.
That's correct.
Okay,
The property had already been subdivided. We went through the concept, the PEC concept plan and the PEC preliminary plan process for all 90 acres. And then, this is the term of art, was because of the county's stormwater management review process, made us modify some of the terminology.
Right.
And then we went into the individual parcel site plans or parcel subdivision plans, preliminary and final.
so even though this is where, every time I think I have it, you sort of get me off here. So just bear with me for a minute, and Mr. Chairman, I hope you don't mind.
We need this.
The PEC preliminary plan is, you have a concept plan. Is that the first document that was
Yep.
approved?
That's the bubble diagram.
Right.
That's what looks like this. The PEC concept plan shows all 90 acres, and this is what it looks like,
Right,
okay?
okay,
Without my
that's fine.
red marks on it.
And look, can we put that into the record as the concept plan?
It's already,
That's in the
okay,
record, all right.
this has got my notes on it, I prefer not to, it does not be, it's part of the overall approvals for the, I mean, it's already part of the town's records.
Ms. Levan, do you have a comment?
Is it part of the record? So, I'm concerned about the testimony because you said, you referred to this, right? And I don't think that this is actually a document that's in the record.
Okay, so if it would help, the PEC concept plan was approved in 2016. It's the approved PEC concept plan from 2016.
Is that the one we've been referring to in the pattern book?
No, that's the PEC preliminary plan.
Oh,
This is
concept,
right.
yes.
This is the concept. It's the overall bubble diagram, and then you've got the PEC preliminary plan.
Is the concept plan?
But the preliminary overrides the
You know what I'm
concept.
saying, is
I
it
mean,
part of 04?
meaning it's
It
approved,
reinforces
it's,
it.
it, yeah, reinforces it, it's
That's
cleared up.
what I wanted to get to, that's exactly right.
May I?
Yes,
I think the concept plan is critical to what the board is addressing tonight, because the letter from the town administrator opined that the preliminary, the concept plan needed to be amended.
right.
Concept plan?
No, it was the preliminary plan, I think.
Concept,
Yeah,
the entire concept.
yeah, so,
If it helps.
So-
We need to have it in the
I
record.
think we need to have it in the
Yes.
record. If the applicant isn't gonna put it in, I suppose you can put it
I
in
did. I said it's in-
afterwards.
Yeah,
I don't have a copy of Joe's letter.
The concept plan was already entered in.
Mr. Davis, can you proffer that you would put a copy of the approved concept plan into
Yeah.
the record?
Yeah, that's where we entered it in 2023.
And what we
That's why
would
it's not
want.
entered.
Mm-hmm.
Oh, yes, I do.
Yeah.
All right. Let's do this.
I mean, I could just tear these off and just say, here it is.
I just sent the concept plan to Carrie, Sean.
That's the approved.
Okay.
concept
I
plan.
just sent it to her electronically like 3 minutes ago. Okay,
So-
All right,
it's
Terry,
pretty
you
big.
have a copy of that? Terry, you have a copy of that there too? Did you receive
We want to verify with Sean that it was the latest,
Yeah.
was the approved, but I believe it.
You want, what do you want me to do?
Here.
And this is, there's a couple terms used in here. All right.
Yeah, unfortunately, again, the process, the nomenclature of the process got a little screwy because of the stormwater management approval process in Carroll County and how they call what they call their specific approval process for stormwater management.
So you had to adjust all the terminology to comply with their
See, what I want to.
lexicon.
What's important here is this, it seems to me that for purposes of this review,
That's,
we have a concept plan that was approved, you say 2016.
Easy concept plan.
Right, and Carrie, do you have a copy of that? Yeah, has that been, do you have that in your,
I did get it in my email, I'm trying to pull it up now.
okay.
It's
Cl-
pretty close.
Clarification, is this the PEC-1 concept plan?
If that's what you're-
That's,
If that's the document we're talking about, that was already entered into the record on 2025-03. If it's the same document, we can just pull that document.
If it's the
Pulls it
same
out.
as
Wait a
the
minute.
document that I saw up
Wait a
there,
minute.
that is not the approval.
let's,
Got it.
let's keep one at a time. I
Got it.
can't keep track of all
You
the.
can print it and add it after, or they can add it after,
Okay.
if that works for the board.
I couldn't hear you. Let's,
Yeah, let's-
Sorry, I was trying to make sure it was okay with them. I'm gonna make a similar suggestion to the previous suggestion I made, which is, and the clerk is pulling up and there it is, the, concept plan. And, if we can all agree that that's what that is, and say that's gonna be an exhibit, and you can put whatever number or exhibit on it, then when this is concluded, it can be printed and physically added. If that,
check the dates in the warrant.
and we're okay with that, if the board's okay with that, then we'll have an exhibit in the record that is.
I'm gonna check the dates in the warrant.
That seems to make sense.
that sounds good. So you wanna,
I
is
just
there a
wanna
way
check
to,
the dates on that block.
They're not.
do we have a specific number and name for
That's
this?
what we're gonna, you guys have to confirm first it's the right plan. Carrie, what's the, are we up to exhibit 3 or 4?
We are number 3.
3, yeah.
That's what I have.
This is
Yep. 425.
It's the concept plan.
That's super old though.
Right, so it might be helpful to just step back and talk about the overall process to help maybe address some of these questions.
Wait, have we reached agreement on this?
Yes, that is the approved 2016 PEC concept plan.
So is it going to have an exhibit number?
That'll be exhibit 3, I think, Carrie, is that correct?
Yeah, I don't mind if it's 3.
Okay.
All right, that's the first step of this process, it's the concept plan. We now have the approved concept plan in the record as
Yep.
exhibit 3.
Yep.
All right, the next step in that process is what you referred to as the preliminary plan, no,
The PEC
the
preliminary.
my apologies, PEC preliminary plan. And that, for purpose of clarification here, that is not a subdivision plan.
It's not, the property had already been subdivided years and years before the property owner took acquisition of it. It was actually subdivided by the town as part of a subdivision plat that was prepared by Wilson T. Ballard. So
Was this-
when the applicant, or when the current property owner, or the Warfield companies acquired the property, they acquired it subject to the subdivision,
Okay,
which created parcel A, parcel B, C, D, E, F, G.
so what you see, what we see in the concept plan as parcels, as you said, E, A through G,
H, I think.
oh, there's an H, you're right, apologies. A through H has already, it was already subdivided, they were already subdivided.
Yep.
Okay.
They were pre-existing, in other
I
words.
did not realize that, my apologies.
Can Mr. Chair, may I just want to clarify.
Speak up,
something.
please. I can't hear you.
I'm so sorry. I think we need to clarify one other thing, because I think the witness was talking about building F and building E as something distinct from the parcels. Am I correct about that?
Ask your question.
I'm just, again, because we're trying to clarify what we're talking about. When the witness was talking about the parking, adding the parking, changing the
Building
parking
F.
in the right of way,
Building F.
building F, which is something different from parcel F, correct?
Correct, it's parcel B.
Right, okay, that's all.
Yeah, I was okay there. My point of trying to get some clarification was, I'm referring you, in Joe's letter, he goes, process follows same steps as original PEC approval, concept plan, preliminary plan, and final plan / subdivision. I assume that when we say concept plan here, it means PEC concept plan,
I believe he does too, and that's one of the reasons why we're appealing
okay?
that letter.
And PEC preliminary plan, and PEC final plan subdivision. They're all PEC, correct?
No.
Or not?
It goes PEC.
Except for the site plans.
Correct. It
I
goes
get that, but
PEC
even-
concept, PEC preliminary, and then you go into the preliminary and final.
I'm just talking about the 90-acre drawings.
Correct.
Those
So
are-
we went from that concept plan, which was approved in 2016, to the overall PEC preliminary plan, which includes the entire property.
Right,
It is a package that the town is in the town's records, it was approved.
Okay.
It is 7 pages long, okay?
Okay.
They have a cover sheet, then you have an existing condition sheet, then you have the grading plan, and then you have, this is the proposed grading, and then you have the proposed landscape plan, and the proposed stormwater management plan, and then the proposed phase plan. So this covered all of those things for the entire 90 acres, okay? And this was based on that subdivision that had occurred prior to them. So all these parcels were subdivided, part of the PEC concept plan, part of the PEC preliminary plan, all that was done.
okay,
And then we said, okay, the first parcel that we're gonna go into and do detailed engineering work for is parcels E and F, Parkside.
Yeah.
So we submitted a preliminary subdivision plan to the town and to the county for their review and approval of that. Things got a lot closer in grading, stormwater management, utility locations, connections to homes, the subdivided lots, all of that was included in the parcels E and F preliminary subdivision plan.
So when you had parcels E and F, that was essentially re-subdivided into the numerous lots and parcels
Parkside.
That's
that
correct.
you have in, that is now Parkside, that was previously E and F, is no longer E and F, it's whatever the denomination is.
It's Parkside. It's,
Okay.
it's
But it's still, I would
Parkside.
assume each townhouse lot has its own lot
Individual
designation and
address.
all that. Okay,
Absolutely.
when
understood.
E and F was approved.
Oh, yes, it's built.
Okay, oh yeah, but when that happened, where it materially changed the bordering roadway, I guess that's Warfield Road,
Right.
so forth. Did that have to be reflected back on earlier approved
No.
90-acre plans?
There were modifications to the preliminary subdivision plan for parcels E and F and the final subdivision plans for parcels E and F that changed from the PEC preliminary plan. As we got more into the engineering and the plan evolved, we had to make modifications to that. To the to the preliminary.
Which
plans.
part?
The preliminary subdivision plans, just for parcels E and F.
Even, that's what I'm
We
saying.
never went back in and changed it.
Beyond E and F, outside of E and F, were there any material changes caused by that were never reflected on the larger, the 90-acre drawings?
No, they were never, we never went back in and modified the concept, the PEC concept plan.
No, I didn't ask you if you did it. I said, were there changes made physically, construction, engineering and changes that were not then reflected on the overall site plan, the entire Moorfield plan drawings?
No. If I'm understanding your question correctly, I want to make sure that.
So you didn't affect the overall, you only affected E and F?
That's correct.
Okay, that's what I was trying to
So
correct.
we had made modifications
Okay.
during the preliminary and final subdivision plans for E and F that were different than what was shown on the PEC preliminary plan.
If you had made a change that would have going to like change the alignment of Warfield, would that have had to be reflected back on then the other drawings?
It was not required when we went through the preliminary and final site plans for building F. Okay?
For built, now, you're in another
That's
building
parcel
F,
D.
that's that's partial,
We've only been through 2
okay.
parcel.
Did you change the alignment of the road?
We added all the parking to it.
You added, but you didn't change the alignment of the road.
We didn't change the alignment of the road, but we added a lot of parking to it. We changed the access point from Warfield Avenue
Did you
into.
change the width of the road?
Didn't change the width of the road. No, we
Okay.
changed the access point, and we changed the park, and we added parking into that.
Parking is striping?
Oh, no, we added paving to account for that parking.
Then you did change the width.
Correct. We did change the width of the paving section, but not of the road itself.
Mr. Chairman, if I may.
Okay.
So essentially what you're saying is that the road, as it was reflected in the original subdivision plan, the right-of-way width and its alignment did not change.
It did.
Okay.
The center line stayed the same.
The center line stayed the same, basically.
The lane width
but
stayed the same.
I know, the lane widths changed. We modified, we narrowed down the lane widths. There was a lot of paving out there, so we used part of the paving for parking and narrowed down the travel lanes.
But the approved right-of-way width did not change.
The right-of-way width did not change.
Well, that's the bottom line.
I think at this point I want to put an objection on the record as to the relevance of this entire testimony, because the issue with respect to that's before the board tonight has to do with the fact that a change of use from the concept plan and the preliminary plan is being proposed here. Unless there is testimony that parcels E and F were ever going to be developed without parking, then there's no change. The fact that they moved it from one place to another
She's
place,
testifying.
with respect to the development for those parcels, it's not comparable, it's not analogous, it's not relevant.
I don't know that we're talking about that at all. Ian,
I'm just trying to see how it was handled, Alyssa, in the development of other parcels. If there were areas affected that were not within the parcel, but that were part of, like, I would call it a common area, but I gotta be careful, I know the terminology here. But the common road, and we're discussing parcel B, I believe, tonight.
Correct.
Yes.
B,
Parcel
yes,
B for the Thrive parcel.
Yes.
And if there are changes down there which reflect beyond just within their curb, if there are changes made that reflect back on the main streets, then that, we wanna know, we wanna understand what the correct procedure is. How many plans have to get updated?
Okay, but that's a thing that's gonna happen at some later stage of the development, right? They're gonna bring you a site plan for the parcel that's gonna show you where the parking is and where the building is and all of that other stuff. That's not what the what the zoning administrator told the applicant was requiring the revision to the preliminary plan or concept.
Okay, well, let's,
I would suggest that
okay.
Mr. Chairman, I would suggest that the objection be noted, so that it be overruled, because I think it's all been helpful to clarify what we're discussing this evening.
Yeah, I understand that, Alyssa. I think we're just gonna go ahead and overrule that,
Understood.
but we're gonna note it, and I think we're gonna be focusing on the presentation here of your appeal, because we've gotta understand
It's helpful to have the background.
Yes.
it is, especially with
And
the
it's-
terminology of these plans.
Yeah,
Yes.
unfortunately, the terminology is not great.
Oh, yeah, I wanna be clear, I'm not objecting to any of that.
Oh, okay.
Just, the only thing I'm objecting to is the line of questioning, the testimony of the witness as to the change in parking for the E and F parcels.
I'm just
But-
trying to
but
find
I-
out.
I
Okay.
accept,
This is a D
I
part,
accept the board's
the D
overruling of my
parcel.
objection.
All right.
We're talking about a process here. I think that's the subject of this hearing.
And
Is a-
if I'm not mistaken, I don't think anybody talked about a change in parking on E and F.
No, but we're talking
Well,
about
I'm sorry, building.
we're talking about a process here, and,
Mr. Gosselin, let's just continue on with
right,
questioning. Go on, let's move on.
all right, go forth, sorry.
So, Sean, I think and correct me if I'm wrong, your testimony is that on the page number 2 of the pattern book, the Roman 1 and Roman 2 concept plan and preliminary plan are for the entire acreage writ large, or the entire project, is that correct?
That's correct.
And they don't necessarily have a lot to do with the details of improving one of the particular parcels or more than one of the parcels with actual improvements or a subdivision. Is that correct?
That's correct.
Okay.
All right. Keep going.
All right. What, and forgive me if I've already asked this, I'm trying to remember where you have been already. What did Mr. Cosentini's August 28 letter determine as far as the processing of Thrive's individual site development plan was concerned?
Objection, the document speaks for itself.
I can't hear.
Sorry, objection, because the document speaks for itself.
I still couldn't understand what she,
She objected because the document speaks for itself, it's already in there.
which document?
He's referring to, he's paraphrasing what the August 28th, 2025 letter from the zoning administrator to Mr. Bowersox says, and the letter itself says what it says, and paraphrasing it doesn't add to the board's understanding of the case or what's in front of it.
I was asking a question, and I'm sorry if I didn't use.
Now, Elissa, I need as much clarification as possible because the terms seem to be floating here, and I need to make sure that that we're in alignment with what Joe is, the town manager has put in this letter versus what the appeal is concerning.
So-
And I need to clarify.
So-
Understood, I would suggest that the proper witness for that is the person who wrote the letter.
But that's what we're appealing.
All right, so
Understood, but if you, I'm not
Sorry.
arguing.
Well,
let's.
let's hear what you're appealing, because maybe you're appealing, you're
We're
mistaken.
appealing what's
you're
exactly in the letter.
Well, that's what I want to
But
get.
that's the issue. That's why we're here, is the zoning administrator wrote a letter identifying an approval process, and we don't agree with that recommendation, or what he has determined as the approval process.
Yes. All right, well, I will note the objection there, Alyssa. From point of order, but go ahead, I would like to hear this.
So, Mr. Cosentini's letter specifically says the town's site plan process begins with a concept site plan submission to the Planning and Zoning Commission. This step provides the commission with sufficient information to determine whether the proposal is practical and suitable to move forward. Once the concept is approved, the applicant may proceed with submittals through the technical review agencies in Carroll County. That process can be detailed and requires several iterations. When all agency reviews are fully completed, the applicant may return to the town's Planning and Zoning Commission for consideration of final site plan approval. If you look at that, if you read that statement and you look at the approval process as identified in page 2 of the pattern book, which we've just reviewed, there is no concept site plan submission. It goes directly to preliminary plan, and the preliminary plan goes directly to the county and the town.
For development.
For the development review process. So there's no concept to final, it's preliminary to final, and both the preliminary and final require the county's involvement in that review. And that's what we're asking for, is there's no reason to submit a concept site plan for this.
So, and again, you've just talked about something referring to an individual site development plan.
Yes, that is
Okay.
correct. Okay? It goes on further to say, in cases where a proposed site plan does not conform to the approved preliminary PEC plan.
Where are you?
I'm on the third paragraph. In cases where a proposed site plan does not conform to the approved preliminary PEC plan, a PEC amendment is required under section 180-144 of the town code, which governs amendments to the planned employment center district. This process follows the same steps as the original PEC approval: concept plan, preliminary plan, and final plan subdivision. Where the zoning administrator determines an amendment is not substantive, the concept and preliminary phases may be combined into one preliminary plan submission. In the case of parcel, and I'm skipping down to I can finish that paragraph, let me just.
I see.
Each step requires review by the Planning and Zoning Commission with technical review occurring through the county in parallel. All plans must be prepared by a licensed architect, registered civil engineer, professional landscape architect, or other qualified land planner. In the case of parcel B, the concept site plan that has been shown through the conditional use approval process proposes modifications to the internal roads and parcel entryways that are different than on the approved preliminary PEC plan. These changes can affect the design and functionality of environmental features across the larger Warfield development. For this reason, a PEC amendment is required so that these impacts can be accounted for comprehensively prior to the individual parcel development moving forward. Accordingly, parcel B may not proceed independently of the PEC amendment process. So that is the second part of what we are appealing, that we do not believe that the changes that are proposed in parcel B for the conditional use are substantively different than the approved PEC preliminary plan. And therefore, we don't need to go back through the PEC concept plan and PEC preliminary plan. We can move straight to the preliminary site plan and final site plan with a technical review by the county, as we did with building F in parcel D. Internal roads had changed in building F, and access point had changed in building F from what was shown on the approved PEC preliminary plan. We were not required to go back in and change the PEC concept plan nor the PEC preliminary plan to account for that. We were allowed to move forward and get those site plans approved, which we ultimately did and got final site plan approval in 2019.
The relevance that I've already articulated, and I understand what the board's position is, but I'm putting that on the record.
So it's
The objection. Just note the objection.
Yes,
To the relevance of what happened with building at ENF.
all right, so noted.
We
All
went
right.
through, we went through a process, and we're asking basically to go through the same process we went through with parcel B. We went through a process for parcels E and F. We went through a process with building F. We want to go through the exact same process for parcel B. And we're saying, and the zoning administrator, Mr. Costantini, has said, no, you can't go through that process. You got to go back in and change the concept, the PEC concept plan and the PEC preliminary plan before you can go through that process or concurrently with going through that process. The issue that you have here is when you go through the detailed engineering, it informs the PEC preliminary plan. Okay, what we're showing here would go back in and you would technically get the approval and then amend the PEC preliminary plan. We're trying to amend the PEC concept plan as we speak, as you know, through our variance request and through the submissions that we've made. So we're in the PEC concept plan revision process now anyway. But the detailed engineering for parcel B, where we're putting the stormwater management, where those roads actually tie into Warfield Avenue and the access onto the Northrop Grumman site, okay? The grading, there's a gas line, how we're gonna relocate that gas line. We showed it generically in the PEC preliminary plan, but when we get into this level of engineering, you're going into a much deeper dive into it. It's taking engineering from 25% to 50 to 75%. That informs the PEC preliminary plan. Otherwise, we'd be stuck in this circle of, okay, we're updating the PEC preliminary plan based on what we know, but now we're gonna go in and we're gonna update the preliminary site plan for parcel B, which is gonna show changes from what we showed then, because now we know more. Oh, now we gotta go back in and update the PEC preliminary plan again, and it's just an iterative process. That's why we went through the same process we're asking to go through here. That's why we went through it in parcels E and F on Parkside and Building F. Because we knew going through that detailed engineering process was going to inform the revisions to the PEC preliminary plan.
Is Warfield being developed? Are there multiple parcels being developed concurrently?
Not at this time, but ideally there would be.
Ideally, there would be.
Yeah.
So if you're making material changes that would inform the preliminary plan, it seems to me that those might impact another project that's going on that also needs that site plan to be correct or accurate or most up to date. Is that
Which preliminary plan? The
Any
overall
other-
PEC preliminary?
any other parcel plan?
It's not, I mean, in any large multi-parcel development like this, individual parcels come in as you have a specific user with a specific, you look back to the overall approval. We believe that these changes that are being proposed in parcel B are minor and they're not substantive, and therefore we don't need to go back through. Showing an access point onto Warfield Avenue and onto the access onto the Northrop Grumman site is not material in my opinion, because what would happen in parcel C would be informed by that.
Where is the control point in this development? Who is controlling it? Is there a central point of control as to how each parcel gets developed and how it may or may not impact adjacent or opposing parcels?
I think that's collectively the applicant and the town. I think the applicant comes
So
forth.
Joe represents the town, our town manager represents the town in terms of a point of control.
Correct.
Okay.
And we do too.
And
the
but you're going
applicant-
deeper into the engineering.
Correct.
And you're doing this detailed development.
That's correct.
Okay, so there's,
And so our opinion is that the change that we're asking for in parcel B is minor. And we don't need to go all the way back through to the beginning, to the concept plan or the PEC concept plan or the PEC preliminary plan. We can move forward with the preliminary site plan,
okay.
and it would be a preliminary site plan, not a concept site plan.
So is your appeal accurately then detailed here on this part of your application has specific details of appellant's appeal of town manager's decision? Is all that information correctly represented in
We're
here?
trying to explain that to you now.
Okay.
Mr. Chairman?
Yes, sir.
Sean, if, let's say, whether this happens or not, I don't know, but let's say you develop parcel B, as you seek to here, but it turns out that there are going to be impacts on, let's say, the alignment of Warfield Avenue or other potential impacts on issues that are shown on the preliminary PEC plan. Would it be your position then that you then need to go back and amend the preliminary PEC plan?
After we get through the detailed engineering and approval process for parcel B, yes.
And you would not be able to get final approval of parcel B unless and until then you obtained the necessary amendments to the preliminary PEC plan.
No, because again, as you move through the engineering process, it gets more and more and more refined. That's what we learned with parcels E and F. That's what we learned with building F. Things were changing because of sewer connections, water connections, so on and so forth. So I think the most appropriate time, if we don't think it's a substantive change to what was shown on the PEC preliminary plan, let's go through the approval process, the site plan approval process, preliminary and final site plan approval process for parcel B, and then we can go back in and we can revise the PEC preliminary plan to reflect those, so that the next user would come in and that would be accurate. And that's what we're in that process literally right now, in terms of trying to amend the concept plan, and then from there we would amend the PEC preliminary. I'm sorry, we're in that process to amend the PEC concept plan, and then we would amend the PEC preliminary plan.
Mr. Davis, let me ask this. Isn't the appeal in case 02 of the Planning Commission's decision, isn't one of the changes you're looking to make in your revisions dealing with some of the open space issues that were created in other words, addressing the open space areas that were addressed that were included in parcels E and F when that was ultimately subdivided.
And record.
Objection. The applicant asked to postpone the consideration of that case, and the board postponed the consideration of that case, and I object to the testimony about what they are or are not asking for in that case.
We're just using it as an illustrative example of.
Yeah.
So noted.
And it's set forth in our application in that case.
I think it's from a conceptual standpoint, we're trying to do an analogy. All right, do you have anything else?
Yes.
Okay.
In his August 28th letter, did Mr. Cosentini determine that he believed parcel B plan was different than the approved Warfield concept and PEC preliminary plan?
Same objection.
Was that a question or a statement?
It's a question
It's a
of my
question for me.
witness.
Oh, okay.
So, yes, he did. I mean, he said that there was differences enough. He never says substantive differences, but he says there are differences enough that, in Mr. Cosentini's opinion, it requires a modification of the PEC concept plan and PEC preliminary plan.
And you may have addressed this before, but do any or all differences between the individual site development plan and the approved PEC concept or preliminary plan require go back to the beginning process that Mr. Cosentini discusses in his letter?
No.
All right. And is that having to deal with the substantive change you referred to earlier?
That's correct.
Objection.
And is the,
Objection, he's leading the witness.
Okay.
is the substantive change actual language in the code?
It's not. Substantive change is not defined in the town's code.
But if a change, doesn't the code discuss what happens with a change that is or is not substantive in terms of that process?
Correct. If it's determined to be substantive, then you go back for the PEC concept plan and the PEC preliminary plan.
All right.
If it's not substantive, you can move forward.
Why do you, and are you familiar with the differences that Mr. Cosentini has identified between the parcel B plan that we're here about tonight and the approved PEC concept and preliminary plans?
What is stated in his letter is proposes modifications to the internal roadways and parcel entryways that are different than on the approved preliminary PEC plan. Those are the only two things that are identified as modifications.
Excuse me, would you agree with that?
Yes, they are different than what was shown on the PEC preliminary plan. I just don't think that they're substantive.
Right. In your opinion, why are they not substantive?
Well, I mean, they don't change the stormwater management, any of the stormwater management design. They don't change necessarily the grading, or, you know, they may actually reduce the need for some retaining walls from what was shown on. I think as part of the conditional use it was approved, it was determined that there was less traffic with the proposed use than there was for the existing approved hotel use on the site. There's no impact to the existing multi-purpose trail under Route 32 to Warfield Avenue and Cary Dorsey Park. It's a less impactful plan than what's currently shown in Parcel B. And I think that the internal roadways and parcel entryways, we've dealt with that with Building F. We made modifications to the internal roadways and entranceways on Building F, and it was determined that that was not substantive enough to require us to go back and modify the PEC concept plan and the PEC preliminary plan. So, I mean, that is, if you will, you know, a course of action that the town's taken, and that's what we were relying on.
So you're acknowledging that there are or may be differences
Yes.
in parcel B versus the PEC concept and preliminary plan.
Yes, there are.
You don't believe they are substantive.
That's correct.
And you've talked about other sites, parcels E and F, and then building F on parcel D having gone through
Yep,
to completion,
correct.
final approval of the individual site development process.
That's correct.
Were there different, and you talked about some differences, particularly with building F on parcel D, between that site plan and the Warfield PEC concept preliminary plan, did you not?
I did.
In your opinion, were those differences of similar impact to the ones that you've identified as differences in Mr. Cosentini's letter?
I think they're very similar. The changes that we made for the preliminary site plan and final site plan in Building F are very similar compared to what was approved in the PEC preliminary plan, are very similar to what's being proposed for parcel B for the Thrive facility.
So any changes are not of a different nature than ones that have already allowed building F, building F and parcels E and F to move forward
That's correct.
to final approval. Can any ultimate differences that are shown to exist between what happens on parcel B when it's to be built out?
Parcel B, we're talking about right there.
Parcel B,
Right.
yes, the Thrive parcel,
Right.
the conditional use parcel. Can any ultimate differences between what happens on parcel B through the individual site development process and the Warfield PEC concept and preliminary plans be identified without the benefit of processing the individual site plan for the Thrive site for parcel B?
They can't. That's what we were talking about earlier. You would get into this circular process where, okay, we're submitting a revised PEC preliminary plan based on what we have today, but then we're going to go through the detailed engineering process with the county and the town, which is going to make modifications to that PEC preliminary plan. We're going to have to go back to the preliminary plan and modify that. And as we continue to go through this process to do the detailed engineering and approval for parcel B, we would constantly be having to update the PEC preliminary plan to match those modifications. It would just be this circular process, which is why, again, why we went through the process that we went through on Building F.
So can any revised Warfield PEC concept or preliminary plan be processed incorporating any changes in the Thrive plan without the Thrive plan being reviewed beforehand?
It would be fruitless. No, they can't.
Next question.
Go ahead. I have a couple myself.
Can you, Mr. Cosentini indicated, he stated here in the letter, these changes can affect the design and functionality of environmental features across the larger Warfield development. You're telling us, I think, you're suggesting here that the changes that you're proposing here would not do so.
There's no there's no delineation of what those environmental features are.
Understood. Can you?
And I don't believe that there are any changes.
Can you though tell me, let's say theoretically, can you tell me theoretically the type of changes you think could affect other changes across the larger development? Can you conceive of, in other words, give me an example of if you think this is not going to affect that, what kind of changes would affect the larger development?
Stormwater management, probably the single most important thing. If the stormwater management changes where we could not handle stormwater management for parcel B on parcel B, and we had to allot for stormwater management on another parcel to handle what is being proposed here, that's a substantive change.
You mean like a drainage ditch?
Well, they don't do drainage ditches anymore. They
Whatever
do
they're
these
called.
bioretention facilities and, a variety of different techniques. If we can't handle that on parcel B, and we have to go into another parcel to handle it, that's a substantive change. But we
So-
don't see that.
That's something you think would require a preliminary plan change before you get to this particular subdivision?
I mean, that could rise to it. I don't, personally, I don't think that that would be necessary, because again, you would have to go through that process. And for the record, what's being proposed on the Thrive plan is less impervious surface than what was proposed on the approved PEC preliminary plan.
For the hotel.
For parcel B, yeah, for parcel B, for what was the hotel and parking and
So-
all the improvements we are proposing less impervious surface than what was proposed there.
So there will be no impact elsewhere on the property, as a matter of, you know now, because of that fact, that stormwater management on this property will not have any effects elsewhere on the property, on the
Correct.
Warfield property.
That's correct.
Okay.
We believe we've been able to address the necessary area for stormwater management, but we will go through that process with the county. That's part of the technical review process in the preliminary site plan.
And if the county determines that, let's say, for the sake of just this example here, that the county says, no, we don't agree with your proposal for stormwater management, and we think you need additional, larger stormwater management, whatever it would be, that could have impact elsewhere on the property, what would you do at that point?
I think we would come back and sit down with the town and the county and talk about it and see whether or not we need to go back in and revise the PEC concept plan and PEC preliminary plan at that point in time. Because again, we would get back into that circular approval process where, okay, now we're going back in and revising the PEC concept plan and PEC preliminary plan based on 30% design of stormwater management. But then we get to 75%, we realize, oh, we don't need that anymore. We're able to do X, Y, and Z, and that's not necessary. So it just changes. Again, you got to go through the engineering process to appropriately inform the revisions necessary to the PEC preliminary plan.
So, Mr. Davis, if I may, to follow up, Mr. Taub just gave you a what if about a serious or substantive change, and we've talked about stormwater management that would affect more than just parcel B in some significant way. Is there any way to find out if the stormwater management needs for the site are in fact of that magnitude, unless and until you go through the individual site plan review process?
No, there's no way to find that out. We have to go through the detailed engineering approval process for the detailed site plan.
Well, let me pause this at the moment. I've got the information. There is a page here which has, I think, your delineated specific points that comprises your appeal. Is that correct?
They were various aspects of the August 28th letter.
We're trying to boil this down to,
I'm
I'm trying to
distill-
find out what your appeal is and what relief you are seeking. What is your proposed solution? Because I want to have the town manager have a chance to present his
Understood.
letter and the reasoning behind it and the processes that have been in place here, and how we can bring these two sides together and get this resolved.
Simply stated, we would like for the Thrive Parcel B site development plan to be decoupled from the need to be included in a Warfield PEC preliminary or concept plan revision at this time. As we have done with parcels E and F, and as we have done with building F on parcel D.
And then how would you ultimately then, what are you, you're proposing is that you would develop that individually and then go back and update the,
PEC preliminary plan accordingly.
Right, and we're in the process,
And what-
we are in a stalled process of trying to do that now.
at what point would you feel that you're ready to update the preliminary?
Once we know what the impacts are.
That's the engineering
That's
process.
the final engineering. Exactly what we did with building F and parcel D.
All right, is there any other testimony you want to give that will further confuse me, or further?
Oh, I understand, it's, not for the faint of heart.
I'm trying to get this down to Charlie Irish's final figure here, and
Yeah.
you gotta be old to know what that means.
Simply, we want to follow the process that was identified in the pattern book. We want to be
A
able.
process, and I want to make sure that the town has their process
And it's a
properly
it's
represented.
the same process that
Okay.
we were permitted to do with parcels E and F and with.
Fair
W.
enough. Fair enough. Is there any other substantive testimony, or do you think it's a good time to hear the town manager?
Do you have anything more? Okay, I don't have any questions of Mr. Davis. If I could have a brief recess and speak with my clients. to
Sure.
Find out.
All right, we'll take a brief recess for the moment, for about 5 minutes.
So can I just establish if we're having recess, it's not to discuss Mr. Davis's testimony?
No.
Okay.
All right, this meeting is back in session. All right. If there is no further,
I have no further witnesses in my case in chief. Depending on what comes up, I'd like to be able to cross-examine Mr. Cosentini, and we may need the need for some rebuttal thereafter, but
I think we can handle that. All right, so now we should hear from the town staff. Mr. Cosentini, you need to be sworn, that's right.
As an individual who wishes to testify in case 2025-04, do you solemnly swear that the testimony you are about to give at this meeting shall be the truth and nothing but the truth?
I do. Thank you, Mr. Chairman and members of the board. I'll walk through kind of the staff's position and the reasoning behind the letter that is subject to appeal tonight. So the appellant has challenged the explanation and the appropriate review process for a site development plan for parcel B within the Warfield PEC district.
Please
Yeah.
keep the voice up.
Use the outside voice. They have argued that the letter is arbitrary, capricious, unreasonable, and legally erroneous. Staff's position is that the letter is none of these things. The letter is straightforward application of the town's code requirements within the PEC zone. So when reviewing a claim that an action from an administrative official is arbitrary or capricious, the board must determine if the action was based on the town code as written and the facts presented. If both are present, then the decision is not arbitrary or capricious, even if the appellant disagrees with the actual conclusion in that letter. So the core question here is, does the proposed parcel B plan conform with the approved preliminary PEC plan? The letter states that a site plan can be submitted at any time and details the review process for a plan that is consistent with the PEC preliminary plan, and one that is not consistent with the PEC preliminary plan. Staff then indicates from the information we've seen thus far that the site plan is not consistent with the PEC preliminary plan. I want to keep the nomenclature as clear as possible. And that it should be noted that no official submission has actually happened. We haven't received any plan yet. What we're saying is the use and the layout of that plan doesn't show the same thing on the approved preliminary PEC plan. So the town's adopted process is clear under code 180-144B, where it states any amendment to the plan must go through the same three-step approval process, referring to concept, preliminary, and final. This is a mandatory framework. The code does not invite judgment calls about whether differences are minor, inconsequential, or refinements. It simply requires that changes from the approved PEC plan go through the same three-step approval process as the original plan went through. So in reviewing the information available for parcel B, staff identified multiple inconsistencies with the approved preliminary PEC plan, including internal circulation, parcel access, development configuration elements, including the use of the parcel itself, and the overall development mix that effect would have on the overall project. Because these deviations cannot be reconciled with the approved plan, staff correctly determined that the PEC must be amended before or concurrently with the site plan approval process. This conclusion directly reflects the code's requirement and therefore is not arbitrary, capricious, or unreasonable, or legally erroneous as the appellate claims in their application. The appellate lists 6 reasons why they believe the determination is improper, and I'll address each in turn. Number 1, their site plan should be processed solely under the 2017 Development Pattern Book. And once approved, it supersedes the preliminary plan. So the Pattern Book is an essential design document for certain, but it does not override the town code. Neither the Pattern Book or any local procedure authorizes the site plan to automatically supersede an adopted preliminary PEC plan or bypass the PEC amendment process. The code gives the preliminary PEC plan legal significance. The Pattern Book implements the preliminary plan. It does not replace it, alter it, rise above it. Any change to it must follow 180-144B, and staff's advice simply follows that requirement. So number 2, any difference between their plan and the preliminary PEC plan are not substantive or material. Again, the code does not create a threshold for materiality. It allows the staff to waive a PEC procedure because changes, or it does not allow staff to waive PEC procedures because changes seem small or reasonable. The standard is not whether a change is substantial, it's whether a change exists. Once the site plan no longer conforms to the approved preliminary PEC plan, the amendment process is triggered. This is an objective standard. Staff did not and cannot apply subjective judgment about how different is too different. And this is specific to use of the property. So it's a very different use that's happening on parcel B as what's approved in the preliminary plan. So this is the exact opposite of what arbitrary decision making. It's adherence to the code, that's it. So number 3, there were no environmental features designed or technically reviewed at the preliminary PEC stage. The preliminary PEC plan includes land planning elements that were officially approved. Those approved elements including environmental areas, open space patterns, and site organization, including the commercial business mix, cannot be altered without a PEC amendment, even if technical engineering was deferred to a later phase. The code again provides the mandate. Staff is simply applying what the code says. Number 4, differences in internal roadways and parcel entryways are mere refinements of the sort normally addressed during technical site plan review. Roadway alignment and parcel access are core components of the preliminary PEC plan. If an applicant proposes to reorganize those elements, that is precisely what the amendment process exists to ensure coordinated development along the entire PEC district. Number 5, other site plans with similar refinements have been processed without PEC amendments. So the applicant has provided no examples and no documentation, no record to support this claim of parcels where uses themselves have changed. So on parcels E and F, it was a townhouse development as part of the original PEC plan. It is a townhouse development today. On building F, it was an office building. It was proposed as an office building. It was just minor parking that was changed around it. And then number 6, so for other reasons as the appellant may present, staff is confident that the record already contains all relevant considerations that the letter sent, fully explained and appropriately tied the requirements to the town. As far as, it's been suggested that because the Planning Commission and the BZA unanimously approved a conditional use for parcel B of the assisted living facility there on parcel B, that the town somehow waived or eliminated a requirement for a PEC preliminary plan amendment. With respect, the interpretation is not either supported by the zoning code nor consistent with established planning principles. When the use changes, the overall mix in the entire development has changed. So therefore, the plan needs to be, preliminary plan and concept plan of the PEC zone needs to be updated. A conditional use approval for the PEC preliminary plan serve fundamentally different purposes. A conditional use evaluates whether a specific use type, in this case an assisted living facility, may be permitted on a particular parcel as a matter of land use compatibility. The board's review properly focused on operational conditions such as neighborhood impact, traffic generation, and other criteria directly tied to the appropriateness of the use. But the conditional use approval never substitutes, alters, or supersedes the town's requirement for site development to remain consistent with the governing PEC plan. That requirement is codified under 180-144. It applies to all development within the Planned Employment Center District, no matter how many times the Planning Commission or Board of Zoning Appeals may vote on an individual use request. So to put it plainly, a conditional use approval determines whether a use is allowed. A PEC plan determines where and how the project physically fits within the larger coordinated development framework. These are not interchangeable processes. They do not overlap, and approval under one does not excuse compliance for the other. In the case of parcel B, the approved conditional use did not and cannot modify the approved PEC preliminary plan. The PEC plan for Warfield is a master plan document, a master development document that dictates roadway alignments, parcel access points, internal circulation, and the coordinated relationship between multiple parcels. The applicant's current proposal changes several of those elements. Those changes cannot be reviewed, evaluated, or approved through a conditional use hearing, because a conditional use hearing does not examine the broader master plan impacts, consistency with the overall PEC layout, or effects on adjacent parcels specific to the PEC zoning context. If the board had intended that the conditional use supersede or alter the underlying PEC preliminary plan, the board would have had to explicitly state that intention during the zoning code review. But no authority for the BZA to amend the PEC plan exists, even if it wanted to. Under 180-144, only the Planning Commission can amend the PEC plan, and it must occur through the prescribed PEC amendment process. The unanimous conditional use approval simply confirms that an assisted living facility is an appropriate use for parcel B if it can be designed in a way that is consistent with the approved PEC plan, or if necessary, properly amended. The conditional use approval was not a waiver. It did not rewrite the PEC, and it did not grant the developer permission to disregard, bypass, or reinterpret the zoning code. The correct process remains exactly the same as it's always been. If a site plan is inconsistent with the approved PEC preliminary plan, specific to the use of the property and how that use is going to affect the overall mix in the PEC plan, as the case is here, the concepts previously submitted, the developer must obtain a PEC amendment before the planning commission can consider the site plan approval. This protects not only the integrity of the zoning ordinance and the PEC preliminary plan, but also the interests of every other property owner and parcel within the planned employment center who relies on that plan for predictable, coordinated development. So to address the suggestion that the PC amendment process required by the code creates an endless review loop, that would prevent the developer from ever moving forward on parcel B. This claim is simply just mischaracterized, both the process itself and the purpose behind it. The town's process is not endless. It does not create repetitive cycles of review. It is a linear, predictable, well-defined sequence established in 180, 144 of the zoning ordinance. The steps are straightforward: concept, preliminary, final, supported by the county's technical review. The only reason this process appears more complex in this case is because the applicant has proposed a site layout that does not match the approved PEC plan and the use that's contained therein. In other words, this is not an endless loop created by the town. It is a complication created by the applicant's decision to propose a use entirely different than what was already approved in the PEC plan process. If the developer had submitted a site plan consistent with the approved PEC plan, they could already be in technical review today. However, the applicant is proposing a change to key PEC elements. Most importantly, the mix and distribution of those uses within the site. This triggers a PEC amendment, not because staff prefers it, but because the zoning ordinance requires it. The change affects not just one parcel, but the coordinated functioning of the entire planned employment center. The town cannot and should not ignore those impacts. It's important to emphasize that the process is only lengthy when the proposal is inconsistent with the approved PEC preliminary plan. It is the responsibility of the applicant, not the town, to prepare a well-integrated project that aligns with the approved PEC, or, when necessary, proactively requests an amendment to update the PEC. When the applicant brings forward a coordinated plan compliant with the land use percentages requirements of the zoning code, the process moves predictably. When the plans are presented that do not fit the existing framework, they create additional steps. This is not an endless loop. This is a natural consequence of a plan that has not yet met the standards established in the ordinance. At its core, the PEC process is not a barrier to development. It is a safeguard that ensures every parcel fits together in a coordinated, functional, environmentally sound, and compliant manner. The town has a responsibility to uphold that framework, not set it aside because the applicant finds it inconvenient. The suggestion that the project will never move forward if the zoning code is followed is inaccurate and misplaced. The true path to forward progress lies in a complete plan consistent with the PEC framework and a properly submitted amendment. So finally, staff notes that the appellant requests any and all relief available. The BZA's role here is narrow. The board can review whether the letter correctly applied the code, but the board does not have the authority to waive, rewrite, or overlook the procedural steps required by 180-144B. In summary, the staff provided the information via letter the appellant requested. The code explicitly requires the change follow the PEC amendment process, and therefore the advice was not arbitrary, capricious, or unreasonable. The appellant retains viable procedural avenues, including presenting their view to the Planning Commission through the concept review process. And for these reasons, staff respectfully requests the board to affirm the letter to the appellant dated August 28, 2005, was not arbitrary, capricious, unreasonable, or legally erroneous. And I am happy to answer any questions the board may have or any cross-examination from Mr. Bowersox.
I have a question. When we, in April of last year, when we approved parcel B for Thrive, there was a condition on that approval. Do you have a note? Can you find that and read that back to us?
Sure.
here
That
if you'd
was-
like me to.
That was, I want to get it out of the town's records. Yeah. Thank you.
Board Chairperson McAvoy, motion to approve the conditional use request made by Thrive at Warfield for an assisted living facility located on parcel B of the Warfield Commerce and Cultural Center with the following conditions. 1, the applicant shall comply with all federal, state, and local rules and regulations applicable to the licensing, establishment, operation, and maintenance of assisted living facilities. 2, the applicant provides additional information regarding the number of deliveries, timing of deliveries, and the types of trucks being used in order to appropriately assess the impact these will have. And 3, the town shall strictly adhere to the town's Warfield Commercial Center New Construction Design Guidelines and Standards for Signs, 2017 edition, when addressing bulk regulations and site development rules. This approval is based on the finding that the request is in compliance with the 2030 Comprehensive Plan, the Planned Employment Center zoning, and meets the requirements of 188-109 of the Town Code.
Okay, thank you. And that was what your letter reflected, that it not only requires that it goes beyond our decision to approve that we can't approve anything that falls outside of the town's code that would violate any part of the town code process.
I mean, that's certainly true. Those recommendations are specific to the use on the site.
Yes.
Again, my letter is more referring to the approval process for how they can get to the point to develop that.
Exactly. So I just wanted to clarify for the record that the board's approval stayed within the confines of where it needed to stay. Conditional use and issues surrounding the conditional use and within the conditional use definition of the new usage.
Right.
Not plans and drawings and
Correct. Yeah.
approval processes.
The conditional use request is specific just for whether or not that use was an appropriate use
Correct.
somewhere on that site.
Thank you, Kerry.
So if I may,
Thank you.
Mr. Chairman, question on, and this is my apologies for my lack of familiarity with the process.
Yep.
So when the conditional use application is submitted, there is no site plan that is submitted with that shows where the building will be located, where parking will be located. That does not go along with.
Well, actually, there was a drawing.
Okay.
Yeah, we had a drawing for
It was
Plan B.
conceptual.
We never
So
asked,
conceptual,
we
so
never
it's
said.
It was conceptual.
stormwater management,
Their
things like
approval
that.
of the conditional use was justification.
All right, so
Not one of the 6.
let me ask you this question. Mr. Davis testified that stormwater management could result in a substantive impact on that property that might have impact on the rest of the Warfield development. And if that was the case, I believe he also testified then that he would agree that that then could trigger an amendment to the preliminary PEC, preliminary plan, and to reflect the impacts elsewhere on the larger property. So are we, but yet, he can't determine that, if I understand correctly, unless he goes into the more detailed site plan proposal that they want to go into here. So are we in a situation where the cart is before the horse? In other words, are we in a situation where we can't really determine if there's going to be an impact of the larger property unless and until they go through the site plan process, which would then potentially trigger that?
Yeah, I think one of the other elements to think about is not just the environmental elements, but it's also the mix of the overall commercial development within the site. So again, there are specific requirements within the PEC district that have certain percentages, land use requirements, floor area ratios, things like that. A change on one of those parcels does have an effect on how the rest of that development can be then coordinated throughout the entire parcel. So a change on one parcel, say the intensity or the overall floor area ratio increases in intensity from what's on the approved PEC preliminary plan. well, then that has a trickle-down effect to every other parcel around until there's a coordinated plan that's kind of put together to show how that new coordination is gonna happen, how that new business mix can still meet the conditions in the code.
So in short, what we're saying here is that Mr. Davis is focusing on the engineering aspects of the property, and you're saying we also have to look at the use aspects of the entire
Absolutely,
development, and that's not being considered in this,
that's correct.
in this application.
Okay, we gotta chime in here.
May I? So there is a stage at which the engineering considerations will be reviewed and approved, correct?
Yes.
And what is that stage?
So, well, again, after you get through concept and preliminary PEC plans get approved, then you do start going into individual site review.
And they won't have to come back and change the PEC zone at that point. They can modify the site plan that they're submitting.
That's correct, for the site that they're looking at.
Exactly. So the review of the PEC preliminary plan is an assessment of the way the entire the entire project works together.
That's right. Again, so the land use percentages that are within the PEC zone, within the zoning ordinance itself, are very specific. You know, they have to meet so many percentages of acres have to be commercial or residential or industrial, whatever. So again, when you start changing the uses on the individual parcels, not only does that potential have a
Commercial. It's commercial.
like road alignment issues or changes, there's a different mix of businesses that are now need to be allocated within that parcel.
I'm sorry, go ahead.
I'm sorry. You can supersede me.
Is the conditional use that we approved categorically different from what was on there originally?
No, it's still, it's certainly still commercial. It's commercial
Yes.
related.
Yes.
Yes.
We don't-
It's the same commercial use as shown on the.
Well, we
concept.
don't know how big it is. So again, how large is that commercial use compared to
Well under
what's
the floor area
approved?
ratio.
What do you mean by, what quantity are you talking about?
Well, how big is the footprint compared to what's on the preliminary plan, the approved PEC preliminary plan?
You mean the actual building,
Correct.
right, the
'Cause
hotel
again,
versus the
Because the
assisted
hotel
living?
itself has a number of square feet that's associated with it, and
Okay.
then there's another distribution throughout the site of different commercial uses. Well, once you change the one, it affects how you can potentially redistribute the rest of the potential uses throughout the site, which is why you need to update the concept, you update the preliminary plan, so we know what the mix actually looks like.
Excuse me,
Should Mr.
could it please?
Mr.
I'm
Chair,
speaking with mine.
if you need to speak, go outside.
Yeah, this is on the record, it's tough, you know,
Yeah, just.
it's tough to.
May I? So
Let's,
the original use for parcel B on the preliminary plan, the PEC preliminary plan, was a hotel.
Correct.
And is it true that a hotel serves the other uses on the property in a particular way that an assisted living facility does not?
Right, so the current PEC preliminary plan shows a significant amount of office use. So a hotel is supplementary to that. It's can't think of the word. Well, it supplements the use of an office. So if people are coming in to visit for meetings or whatever, they have a place to stay. We don't know how an assisted living facility is going to then be coordinated with some of those office uses or what's currently shown on the approved PEC plan. So again, you got to update the plan to show how those mixes actually conform to one another or can supplement one another. Again, that's one of the key elements of the PEC zone is that it's supposed to be coordinated, well thought out development, not
And
individual parcel by individual parcel.
is that because it's a planned employment zone?
It is. So again, it's a planned zone. So again, you're supposed to have an overall plan so that you can show how all of those different uses kind of work together.
This, may I,
but I need to clarify one thing, and then, yes. The numbers I'm hearing from Mr. Cosentini are numbers that are developed from the footprint of the the Thrive facility itself, correct? When you talk about square feet,
I'm saying, like, the what they've shown is different than what's on the approved PEC plan.
in terms of square footage of construction.
Correct.
That's only because it's not a hotel, it's a different facility.
Right. It's different
Again,
use.
what we're talking about is numbers, square feet area,
Right.
based on a design, based on a specific
Yes.
size and shape of a building and the interior layout and all that.
That's correct.
So it has little to do with the land around it. The land is the land. It's gonna be parking for one, it's parking for another. I mean, there is less, but maybe some square footage of pervious paved area changes slightly or whatever. But the numbers you're talking about in terms of usage is the building, correct?
That's right.
Not the land, not the site. It's part of it, because that building is what's on that site, I get that, but the numbers are determined by the design of the building, not the layout and the stormwater management of the site.
Correct. That's correct.
But
Does that make sense?
Mr. Chairman, may I? One quick question. In your letter, August 28th, you state specifically that the proposed modifications to the internal roadways and parcel entryways, that this change proposes modifications to those specific things, internal roadways and parcel entryways that are different than the approved preliminary PEC plan. First of all, can you explain to me how they are different, and then how that, you said these changes can affect the design and functionality of environmental features across the larger Warfield development. Can you explain that a little bit more?
Sure. I think that particular comment was related to. So again, if you look at the approved PEC preliminary plan, parcels A and B are combined into one full parcel, where the proposal for parcel B is specific only to that parcel, and it shows that those parcels have now been separated again. So again, they're not being combined into one single parcel. We don't know what the overall impact to the environmental features that keeping that road in between those two parcels is actually going to be until we have a chance to evaluate what that looks like with an updated concept and preliminary plan.
But is the current preliminary PEC plan, does that reflect parcels A and B, or is it simply one parcel, and this proposal is proposing to separate those?
The approved PEC preliminary plan shows them combined into one parcel. And the site plan for parcel B shows only that parcel being developed.
Okay, so that does propose a change inherently to the preliminary PEC plan.
Yes, it does.
Okay.
So what would be the next step?
I think Mr. Bowersox has some questions.
No, not in the meeting.
He means in the
No,
process.
hold on. In the next meeting, if we strictly adhere to this, if this is the controlling process, what's the next step? Since, like Mr. Davis says, they don't know a lot of the design elements until they get into a deeper engineering issue.
They still have to update the PEC concept and PEC preliminary plans to reflect the change of use on parcel B and the roadway layout between parcels A and B. I think at minimum.
Okay, is that something that you already know, basically? You know that the roadway where parcel B ends and parcel A begins? I mean, that was part of the concept for the Thrive facility, was it not?
So unfortunately, there was a very important part of the amendment process that was left out of Mr. Costantini's discussion here. He says any amendment of the plan must go through the same three-step process, and he says, period.
Well, that's what it says in 144.
No, what it says, it goes on, there's a second sentence there, which is the really important sentence, in our opinion. If, however, the town zoning administrator believes the amendment is not substantive, then the concept of preliminary approvals can be combined in one preliminary plan. That's what we're suggesting. we believe these changes are not substantive. Not substantive enough to require us to go back to concept and PEC preliminary plan. Okay, he's basically saying any change, what I heard was any change, you gotta go back, period. There's no, whether it's, he even said minor, any minor change, you gotta go back. And that's not what the code says. The code says, if however the town zoning administrator believes the amendment is not substantive, he's determined that it's substantive. We don't believe it's substantive, that's why we're here. That's for you, that's our opinion, that's your decision, whether or not it's substantive or it's not substantive. That's why we put on the testimony that we did.
All right, fair enough point.
In addition, I would say that there's no square footage that's shown for parcel B on the PEC preliminary plan.
No,
It's a 6-story hotel
right.
with 125 rooms. No square footage. So, and there's the floor area ratio that is permitted on Warfield. We will never be able to achieve the total amount of square footage that is permitted within this project. So
Well, that's-
from a square footage standpoint, that to me is an erroneous argument because there was no square footage that was shown on
Do
it.
you have a proposed square footage for the
No, we don't.
Thrive?
Not yet. We can't. That's part of this process.
Okay.
So
You're not even close?
I mean, we've identified it as a 170 to 190 room facility.
Okay.
That's it. Just like it was 125 rooms. So our contention is a very critical aspect of the amendment process was left out of Mr. Costantino's testimony. And it's that second sentence that says, the town zoning administrator believes the amendment is not substantive. He's saying it's substantive, we're saying it's not substantive.
Sorry, may I?
Yes.
When the PEC preliminary plan was approved, as it exists, showing the hotel use on it, and all of the other parcels with their various proposed uses, no engineering work had been done, correct?
I mean, I'm sure some engineering had been done,
But-
because they had to make sure that it was a reasonable request.
With the kind of engineering they're talking about tonight in terms of.
Detailed 100% engineering on every single parcel was not done.
And yet, it was possible to adopt a PEC plan, which preliminary plan that scoped out basic relationships between the basic uses that were shown on it,
That's correct.
and took into account the various uses on the various parcels in providing a vision, a comprehensive vision for the entire.
That is the intent behind this approval process, is that it's clear that there's an overall thought process that went into how all the different businesses and mixes would work together and make a cohesive development.
Okay.
But if I can, it was also clear.
Wait a minute. Hang on.
All right.
Are you done, or did you have more?
No, that was my answer.
I had a question with regard to that second sentence in 180-144B.
Yep.
It says, is not substantive. Of course, that's a real trap of a phrase because that leaves it subjective.
Yeah, so, well, the only thing that sentence does is it combines the concept plan and preliminary PEC plans. The plan still needs to be amended regardless. It's just whether or not you go through a concept and a preliminary update to the PEC plan, or if it's just straight to preliminary PEC update.
It doesn't avoid it if it's not substantive. It just
It doesn't avoid
says you can
anything.
do the two steps as one.
That's correct.
Do you gentlemen follow that?
I do follow that, but prior practice of the town with parcels E and F and with building F was that there were changes, they were minor, and we did not need to go through the revising the PEC concept plan and the PEC preliminary plan. We were able to go straight into the preliminary site plan and the preliminary subdivision plan. So the prior practice is of the town, and that's all we're asking for, the same application of what the town has done in the past regarding Warfield to this particular parcel.
Mr. Chair, a witness cannot also be a lawyer. If Mr. Davis is a witness,
Answering this question.
I would ask, there was no question pending. I would ask that he be treated as a witness. He be allowed to testify in an orderly fashion, in accordance with the general rules of an administrative process, and that if there is argument to be made, that it be made by Mr. Bowersox.
Well, fair enough. Now, that prior process, you never went through step B,
Step B.
144, item B,
The prior process you're referring to
that you're
is
referring to?
building F in parcel D and parcel E and F, which became Parkside, is that correct?
Yes,
We never did that.
okay.
And the planning commission approved.
When were those done?
Building F was in 2019. I believe Parkside was in 2017 or 18.
17.
It was prior to the building F.
Okay.
Have I answered your question?
Yeah. Creating more.
I know. I know.
Do you have any questions, gentlemen, at the moment while I'm thinking?
Mr. Chairman, may I?
Go ahead.
Mr. Constantini, can you describe exactly what the change was that was made to building F on parcel D?
If I recall, it was just a reconfiguration of the parking.
All right. And if in fact, for purposes of clarification, and Ms. Lemay, I'll ask you for a little leeway here, I would like to ask Mr. Bowersox if he has a recollection as to exactly what the change was to building F on parcel D. Is that accurate?
Parking was part of it, which was necessitated to be changed due to what the county's stormwater review told us, not until we started going through
Understood.
the
Okay.
independent parcel development process.
Right,
They can't be known.
okay. I understand. One other question. If I may, just to get clarification. Can you tell me exactly what the change or changes were on parcels E and F on Parkside?
Well, but the building F was more than parking. I was not directly involved in the project at that time. Mr. Davis can illuminate what those changes were.
I just want to understand exactly what those changes were. And
Mr.
for
Davis
that
is.
limited purpose, I would ask Mr. Davis to limit his statements to exactly what that was, so we all understand here exactly what we're talking about.
I can show you. I have plans here that I have the
Can you
approved
please
piece.
just, is it easy enough to just describe what it was?
I'll try. The parking on the PEC preliminary plan for building F was all within parcel D. We modified that and we moved some of the parking into the Warfield Avenue right-of-way. The connection between building F and the existing Nexion building had 2 access points and it went down to 1. The access point from building F onto Warfield Avenue moved several, over 100 feet, closer to building W. So there were entrance point modifications, parking was relocated outside of the parcel, and access points to an existing parcel and an existing use were also modified.
And after that was done, was the preliminary PEC plan amended to reflect those changes?
No,
Okay. And can you tell me also what was done exactly on parcels E and F? I think it was.
Parkside.
probably the most important
Parkside.
Probably the most important thing is on the approved PEC preliminary plan, we had a large stormwater management facility that was designed outside of parcels E and F in what is now Carrie Dorsey Park. During the approval process for E and F, the county said, we don't want that type of a facility anymore, and everything moved inside parcel F. All the stormwater management, which was being handled outside the parcel in Carrie Dorsey Park, moved into parcels E and F and became a bunch of microbiome facilities and whatnot that are sprinkled throughout the community.
Is stormwater management, are stormwater management facilities reflected on the preliminary PEC plan?
Yes. Stormwater management.
And
the
was
piece.
said the reflect that stormwater management change on parcel?
To do that.
Supposed to be.
That information, we still have Mr. Cosentino.
Mr. Cosentini, should those plans not, should they be amended through this process to reflect those changes, even though it may not have been done in a timely manner at the time for whatever reasons? I can't think. I wasn't here or involved with it.
I think as they're going through the concept plan update, the PEC concept plan update, those changes should be reflected on the new plan.
Is that they can be combined? You think, is that minimal enough to be combined, or is that not, is that substantive that needs to be done separately?
You're talking about, can they just go through a PEC preliminary plan update instead of a PEC concept and preliminary plan update?
Whatever that, end of that, yes, as in 144B. It says, then the concept and preliminary approval steps can be combined into one preliminary plan approval.
I think if they're updating everything that's currently built and the changes to parcels A and B and the uses within the zone, I think that is substantial. And it shouldn't be combined into just one step.
Is that it? So that's individual processes.
Correct. Concept process and a preliminary process.
Would that be the time to include B and also start putting the information to B
Yes.
into the update?
Yes.
Yes. Question, Mr. Cosentino, you just mentioned now there's going to be an update, concept plan update, but when changes like this are made, as they were to, let's say, parcels E&F, stormwater management changes, or the access changes to parcel D, wouldn't that require an update of the preliminary plan at that point in time? Do you have to wait periodically for a major update, or could they simply apply for that? And I'm asking for this informational purposes.
Sure. Yeah, so, changes like that, I'm not sure what the process would be for that, or what would trigger an update for that. Again, we were asked to look at, specifically parcel B. And what are the things that are changing on parcel B that, at least in my opinion, would reflect the need for an update to the concept plan and preliminary plan? And again, it is that relationship between parcels A and B, and the fact that there is a pretty substantial change of use on parcel B compared to what's approved in the preliminary plan.
Mhm.
As to whether or not they can be combined into one step, again, I think they're substantial enough that it shouldn't be that way. They should have the requirement to go before the planning commission, have the planning commission actually analyze how this new use is going to affect the overall plan for Warfield.
Mr. Cosentini, can you remind me when you started with the city?
October 2019.
So after the parcel EF change?
After parcel unit.
Was it after the building F change?
I don't recall. I think I remember seeing that at the planning commission.
That's where I was going. Thank you.
Yeah.
You read my mind. I thought I remembered a change of guard. All right. I think, is there any other testimony that anyone wishes to make towards this case?
With your indulgence,
Excuse me?
with your indulgence,
Go ahead, is this your rebuttal or
No,
your closing
no, I
statement?
haven't even asked cross of Mr. Costantini yet.
You have a clause.
Appropriate.
Is that what?
That's appropriate.
Okay.
Mr. Costantini, you spent a lot of time telling the board about section 180-144 and its implications. You're also familiar with 180-143, I presume,
That's correct?
dealing with the pattern book?
Yes.
And the provision in there that says, once a pattern book is approved, and you're not asserting that the pattern book was never approved for Warfield.
Not at all.
Once the pattern book is approved, the pattern book shall govern development of the PEC planned employment zone. Is that correct?
The site planning process.
Mr. Osborne, can you just tell me exactly what section you're reading from?
180-143A.
A, okay, thank you.
As part of the preliminary plan phase, the development approval process, the applicant shall provide the commission, meaning the planning commission, with a pattern book that will address site planning, architectural, landscape architectural, and signage requirements for the proposed development.
Right. Once approved by the commission, the pattern book governs development of the PEC planned employment center, period. Correct?
That is what it says, yes.
Okay.
And it goes on to list the different elements as to what's required in the pattern book, such as an introduction, the site planning principles, architectural design, landscape architectural design, and a signage plan.
Now, you've made a lot in your testimony out of a change in use. The hotel, was that a commercial use?
Yes,
And is the assisted living facility, as proposed, a commercial use?
yes it is.
And you heard that, did you remember hearing that discussion during the hearing before the Board of Zoning Appeals in April?
That it was a commercial use?
Yes.
Yes.
Do you remember submitting a staff report to the Planning Commission in March of 2005, for 2025, I'm sorry, it's been a long night, addressing their upcoming review of the proposed Thrive conditional use for their review and recommendation?
For the planning commission to
Yeah.
review and give a recommendation to the board of
Yeah.
zoning appeals? Yes, I did.
You never mentioned the change of use at that time, did you?
It was, they were asking for a conditional use to then be added to the overall development plan for the Warfield development.
Right, but it's the Planning Commission. And they were considering whether this is compatible or appropriate, given the overall comprehensive plan, correct?
Whether or not the conditional use was something that could be incorporated into Warfield.
Part of what the Planning Commission is to consider is it consistent
Objection,
with the
this goes-
comprehensive plan?
This
Is that
not-
correct?
This is not proper cross-examination, it goes beyond the scope
I
of
can't
direct.
understand you, I'm sorry.
This line of questioning goes beyond the scope of direct, it's not proper cross-examination.
If this is
Just trying to
appropriate,
get clarified here, listen.
Can you be more specific?
The witness didn't testify about anything that happened during the previous proceeding regarding the conditional use.
he has spent a lot of time talking about how important this change of use from one commercial use to another commercial use, neither of which can really be identified in terms of their overall impact to the parcel B property, much less the entire site. It is such an important thing to consider in sending this, because of the parcel B application, back for concept and preliminary plan approval.
You're suggesting that he should have known.
I haven't finished.
Mr. Chairman,
Let's make the point clear, and then if you have a question, you ask it, but finish your point, sir.
He spent a lot of time doing that. I'm addressing Ms. Levan right now. My question to Mr. Cosentini is, there was no discussion about the impact of a change in use in his report to the Planning Commission.
Because that's not the process for which
Yeah.
that kind of analysis would happen.
And you don't think that was important enough for them to be aware of?
For who to be aware of?
The Planning Commission.
That wasn't what was before them. They were being asked to determine whether or not a conditional use should or should not be incorporated into the overall Warfield site. That was it. It wasn't about what other changes might have to occur within Warfield. There was no question about that because it wasn't ripe yet. We didn't know if the conditional use was even going to be approved.
But
So now that the conditional use has been approved, then now is the time to then go forward and say, well, how is this use going to be incorporated into everything else that is being proposed or is being planned for the Warfield development?
But the staff report does go into detail in describing a number of conditions that were requested to be imposed on their recommendation, including information about design guidelines in the pattern book. Is that correct?
Not design guidelines in the pattern book. There's a separate design guideline document that needed to be
The 2017 guidelines for Warfield
new
for
construction
sign
guidelines.
standards.
New construction guidelines.
I don't think that's what the conditions said.
That is
Objection.
exactly what the condition was.
And the Planning Commission recommended unanimously the approval of the conditional use, did they not?
The planning commission did recommend to the board to approve the conditional use.
Yeah.
Without any analysis on how that use was going to be incorporated into the overall site, because that comes after the Board of Zoning Appeals would approve the conditional use.
All right. So, in fact, this Board of Zoning Appeals unanimously approved the conditional use
They did,
with conditions,
Yes.
which were very similar to the ones the Planning Commission made.
yes.
Why would there be the recommendation in the report to include an enhanced traffic analysis and all of these other, the enhanced traffic analysis and some of these other factors?
Objection. This witness can't answer that question.
He authored the staff report.
Yeah, but I can
You
answer that
asked-
question.
You asked why
Mr.
the
Levan,
decision.
one second, I understand. If the staff report was not what was approved, the planning commission approved the application. That's not the staff. It's different.
Yeah. And the
But
conditional
the staff's
use,
recommendations,
but it's a very limited scope, Mr. Bowersox. We have a limited scope. When we're asked to approve a
understand.
conditional use, we get testimony with regards to the conditional use, the potential impact as outlined in our code. There are a list of items that we consider for every request for a conditional use or variance. And so we look at those items, and we did that evening, and we approved it because it met that. That had nothing to do with Plan Employment Center concept drawings, anything like that. It was strictly, it's like a go, no-go situation. Does it pass the test for meeting all of the requirements that this board is tasked with assessing? And it did, and we were okay with that. And apparently the Planning Commission knows what we do, and that's what they knew, that the scope of what we were going to be looking at, and that's why they unanimously recommended. But that was just one step in a multi-step process for this development. I know we're only part of that.
I understand. Mr. Cosentini, you also talked about a change in the footprint. What was the square footage or footprint of the hotel that was shown as a commercial use on parcel B? shown in the concept plan.
I'm looking for the concept plan. One second. There's no specific square footage listed, just says 125 extended.
There is none.
That's correct.
What is the proposed square footage footprint for Thrive at parcel B?
Well, the footprint that was shown was quite a bit larger.
Do we know the square footage?
No.
Okay. So your comments were speculation as far as that's concerned, is that correct?
Objection.
Objection.
He's arguing with the witness.
No, I'm asking a question.
Either-
Are they speculative comments or not?
I mean, what's the point of the question? What are you
He's
getting
using that
at?
as a basis for claiming that we have to go through a two-step process because of a change in footprints. We don't know what the footprints for either are. How can that be a basis?
That's why they call for the process, to determine that. You have to determine that. You gotta come up with some basis, some delta.
My-
And if
my-
there's an impact on a plan,
So those footprints are still unknown, is that correct?
The exact square footage is still unknown. The concept plan shows what a footprint of the hotel is gonna be. And what was submitted as showing what the Thrive building would be is much larger. The footprint is much larger. Plus, again, the use is different, because again, a assisted living facility is not an extended stay hotel.
Are you suggesting that the approved PEC plan fixes the use in Warfield for another use that's either another permitted, instead of another permitted use, or a use that a Board of Zoning Appeals approves unanimously is appropriate at that location?
I think that's when the updated concept and preliminary plan would come into play.
Okay.
When
And
you
is there-
have, when you have changes of use, changes of size, or let's call it intensity on any particular parcel, it does have trickle-down impacts that can't be evaluated through a conditional use request.
So
It
it-
needs to be evaluated through the concept, the PEC concept, PEC preliminary plan.
So is there any reason why, as the Planning Commission and your predecessor, the interim manager Frank Schaefer, determined with parcels E and F and building F, that these individual site plans could go through and address any need for PEC or preliminary plan thereafter? Why can't this change in use be one of those that's reflected in a subsequent, once we have even more information about what other impacts may be? Modification of stormwater management, perhaps. Maybe modification of square foot, of a street entrance or something like that. Why can't, if that's the way it's been interpreted before, why can that change in use not be reflected on a subsequent PEC concept preliminary plan amendment?
Again, the change in use on parcel B,
Why is that qualitatively different?
it's a change, it's a complete change in use from what was originally approved.
But the
Parcels E and F were 145 townhouses
Right,
on the preliminary plan.
right.
That didn't change. Building F is an office building. That didn't change. The use and the layout of parcels A and B and the change from a hotel to an assisted living facility is starkly different than what happened on E and F or building F.
What is so different about them that a change such as we're talking about with the Warfield PEC concept preliminary plans, for lack of a better lumping them together, cannot be done subsequently to a individual site review and then incorporated in that subsequent PEC concept and preliminary plan amendment process.
So instead of having the two-step process, just having the one-step process,
Why,
but still updating the preliminary plan.
once we know what other changes may be needed, if any, to the PEC preliminary and concept plans, once we can dive into some of the technical reviews that are going to necessarily inform a subsequent revision of a PEC concept or preliminary plan. Why do they have to go separately? Why can't that be done?
Because at no time has the planning commission weighed in on whether or not this change of use for parcel B and its subsequent impact to the rest of the Warfield development actually makes it a well-planned, well-designed, well-thought-out development as required by the purpose statement of the PEC district. None of the other changes that have happened on some of the other parcels included a significant change of use.
What about the finding that this board made, and I believe the planning commission made on the conditional use application, that this did satisfy the purpose of the PEC code, the purpose code,
No.
purpose section?
That's not what it did. So this was a determination, the conditional use was a determination of whether or not a use can then be folded in to what, to the PEC zone. The next step would be then, how does that use actually filter in or mix with everything else that's being proposed there? How are they collaborative? How are those uses supplemental to one another? The planning commission's never weighed in on that.
Can we know what those impacts will be before we have a site plan to evaluate to determine what the size of the structure is or any of those other factors? What I'm saying is I don't see a distinction of any substance between a use at this point until we know more about what this use is going to do to the site than we did in building F with its physical changes or parcel E and F.
So for example, I'll just say, because of what the approved preliminary plan shows, PDC preliminary plan shows, it shows a lot of office use. And I'm not saying that's ultimately what's going to be built out there, but that's what at least the approved plan shows. Parcel B shows a hotel. That was evaluated as saying, oh hey, this is an appropriate collaborative use with the office space that's there. No, the planning commission has not had an opportunity to determine whether or not an assisted living facility is now appropriate for a collaborative use with everything else that's going to happen within Warfield, because they haven't seen that approved use applied to the overall PEC preliminary plan. That's why we need to update it. We need to show, here's where the Thrive facility is going to go, and how is it going to interact with all the other uses that have been proposed.
Didn't the planning commission find?
No, they did not do that.
Let me ask my question.
Sure.
Didn't they determine that the use proposed had less impact on the site than the hotel?
Less impact from
Physical
a
impact.
traffic, sure. To the roads, yes. How does that use interact with the other uses that are going to be built within the overall development? That was never evaluated. How is an assisted living facility supplementary or give extra value to the other businesses and the other planned uses that were within that zone? That's the purpose of the PEC district, is to have a cohesive, well-planned, collaborative development. We don't know if we're individually just letting parcels develop one-offs. We don't know how they're all going to interact together. That's the purpose of the PEC district.
So it's unknown at the present time.
It's unknown how an assisted living facility is going to interact with other uses within the existing approved Warfield development.
I believe that
I have a question. Could they come back and say it won't work?
The planning commission? Potentially.
Why were we given the go-ahead or recommended to approve the conditional use? I'm
Sure.
not defending anything, I'm just now wondering what we did back last April, if we're still back at ground zero, square zero, and now we have to go say, will this work? Well, wait a minute, why did you even suggest it? If you weren't sure, I didn't know if we got the cart before the horse or not. That's-
No. So again, I think conditional uses are, again, the reason they're conditional is because before that use can be implemented into any plan, it has to be evaluated as to whether or not that particular use is gonna have special conditions or special criteria that use has to adhere to before it can even move forward with an overall plan.
So in other words, we evaluated it without regard to the rest of Warfield.
Right. So now that it was determined that, yes, you can incorporate that into the overall plan, well, now the next step is to do that. So let's show how that use is then gonna interact with the rest of the uses that are being proposed in Warfield. And give the planning commission their opportunity to make a determination as to the appropriateness of the entire plan.
Is that also not a dynamic condition that we haven't determined what all the rest of Warfield's gonna be used for yet, have we?
What we do is there's an existing approved PEC preliminary plan that shows uses.
But it's like Plan B changed, other parcels may change? Is that still
That's
a possibility?
That's what we hope to find out
Okay.
through that process.
Okay.
Chairman,
Yes, sir.
it's complicated. In the PEC zone, yes, there's a table of uses, I understand that.
Yes.
But the land use percentages are based on category uses.
Correct.
So if the, and you said that the change from a hotel to assisted living facility, it's a change of use, but it's still, they're still both within the same category of use that is, would be within land use percentages. Is that correct?
Yes.
So if that is the case, why would the planning commission then be required to evaluate the impact upon the entire development if it's still within the same category of use?
Sure, and if you don't mind, I'll flip to the purpose section of the planned employment center zone, which specifically says to encourage orderly staged development in a comprehensively designed mixed-use center. To create a mixture of office, retail, recreation, hotel, institutional, light industrial, and residential uses within a single structure or within multiple structures, where all related structures, parking, open spaces are designed to function as a cohesive and integrated site while protecting the residential character of surrounding neighborhoods. To ensure compatibility of proposed land uses within the internal and surrounding uses by incorporating innovative standards of land planning and site design. The purpose of the district is not just to say, well, you can do whatever you want as long as it fits within these categories. It adds another element that basically says you have to make sure what you pick is coordinated and they're complementary to one another. That's the idea behind the PEC zone.
Okay,
Thank you.
so.
good question.
Mr. Cosentini, in your March 3rd staff report, 2025, you go through an analysis of the impacts, the benefits, frankly, and other impacts that the proposed conditional use could have, including, number one, the number of people residing or working in the immediate area concerned. And you say this can cause an increase in local real estate demand for new families wanting to move in the area, and can have a positive effect on the demand for new local businesses, including medical clinics and small retail to serve the additional population. Are
Excuse
you
me,
saying-
What is the question, Mr. Bowersox?
Or are you saying that this recommendation's been made without considering the rest of Warfield?
I'll say this again. So, a conditional use is not a waiver of any other process. The conditional use sets whether or not the use itself can even be evaluated as part of the overall plan. You have to go through that process just to get permission to even look at it. Now that you've received that permission, now the planning commission has the requirement to then be able to evaluate how that use is going to be incorporated into the overall Warfield plan. It's not a one-off, it wasn't just a one-off, it can't be just a one-off thing. So
So-
PEC zone requires coordinated, collaborative uses to be incorporated together.
So what are the metrics used to measure that?
That's up for the planning commission. That's the.
So you're saying
that's
it's
the
all
purpose of
subjective?
the planning commission. That's the purpose of the PEC zone that the planning commission has to evaluate.
But the,
I can't answer that.
but the planning commission saw what was proposed, just like we're seeing it tonight. No real significant changes. And they recommended the approval of it and found it to be consistent with a comprehensive plan too. I don't, what is the metric? I mean, I'm trying to find out just what's going on
I'll say it
with
again.
what you're trying to get at.
I mean, I'll say it again. The conditional use approval only determines whether the use is going to be allowed within the district.
So it's
That's
subjective.
it. The PEC plan determines how all of those uses then work together. That's the purpose of the PEC zone, and the planning commission is the one that makes the determination as to whether or not those uses are being incorporated appropriately.
Right. So substantive, as used in 180-144, doesn't necessarily say substantive site development reasons or substantive use. It just says substantive, correct?
It does.
And is substantive defined anywhere?
It's not, but the only thing that section does is combine a concept and preliminary approval. That's the only thing it does. The
Okay.
overall PEC preliminary plan would still have to be updated and approved by the planning commission before a site development plan could move forward.
I think we need to move along here and wrap this up. In terms of the case, are there any other,
I have no further questions from Mr. Cosentini.
is there any other testimony that is,
Let me check with my witnesses.
Mr. President, can you, I see you have written testimony, that you, can we enter the written testimony?
Sure.
right,
Mr. Carroll,
Should transcribe it.
may we clean up his notes to reflect what he actually said and then submit it
Sure,
afterwards?
great.
May I ask
should probably
your
do that.
indulgence for a quick break so I can use the mention?
yeah, maybe very quickly, because I think we're going to wrap this up,
Okay, I understand.
okay? Very quickly.
Thank you.
All right, we'll be in recess for 5 minutes. Okay, hearing is back in session. At this point in time, if there's no further testimony to be put into the record, I want to make a motion that we continue this at a future date, which we will try to determine tonight, at which time I believe we will be going into closed session
Right, and
before we render a decision.
that's correct.
That's
And-
correct. And we'll come out of the closed session, go back into a public session to render a decision.
I think, didn't, the applicant has a chance to do like a closing statement?
I thought we'd been through that, I'm sorry.
Oh,
Okay.
I'm afraid not.
All right, then that's, please, sir. Yes.
Do we do it now or at the beginning of the next hearing?
Well, may I, Mr. Chair? I think what we'd like to do, I think what the board would like to do tonight is to conclude testimony this evening. And that's not to say that the case would be closed. Very specifically, it will not be closed, because we would like to, the board will be requesting the applicant and the town to be submitting memoranda as we did for the variances. So there will be an opportunity through that, and that, I don't know if that changes your determination to how you want to proceed this evening, but we do want to conclude all the testimony this evening. We do not want to come back and have any additional testimony, but again, the case will not be closed.
All right, so if that, one other concern, just pragmatically speaking, is we'd like some resolution of this as soon as possible. What is the memoranda process you're considering and the rescheduling look like
We can do
in
it.
terms of time?
I would say, look, this is really, in a sense, up to you and Ms. Levan, because I think it's a question, if you want to have an expedited schedule of submitting the memoranda, that's fine. We're not trying to delay this unduly. You know, I think I speak for the board.
Oh, yes.
We're happy to see this thing get resolved. But the timing issue is really a determination for you. I mean, I would ordinarily suggest 10 days for you to submit, but if you can do it in 5 days, that's fine. And I would say that, and however, I mean, Ms. Levan, you know, do you have any particular problem with an expedited briefing schedule? Call it that.
I have no problem with it. I am in the middle of preparing a memorandum of law that has to be filed in court on Friday. So it would be, I would ask for time, that
Yeah, on Friday.
reasonable time next week
Okay.
to do that.
That's
And
reasonable.
I understand that.
So I'll let you suggest what timing you would like to have here. I think we can move along with it.
Are they submitted concurrently?
Or are they gonna be?
Yeah,
Well-
we are submitting concurrently then to try to expedite this?
Ordinarily, you would submit, because Levan would submit a response, you would have a rebuttal as you did with the variance memoranda. But, I mean, I leave it to you all to determine how you want to deal with it. So, I mean, frankly, I think on behalf of the board, I don't think there's, you know, it makes much of a difference to the board.
As long as you get your issues, you're
Addressed.
on the same
Right,
plane.
we're gonna be dealing with the same issues.
Right, if the memoranda are essentially closing argument based on what was said tonight and new issues are not gonna be raised, I don't have an objection to a concurrent submission.
That's, I think that's fair.
Yeah, I think certainly, I think it's important to understand that the memoranda should not include any issues not raised this evening. That they should be limited to the issues that were raised during testimony on your case and the testimony by the town.
Could you repeat that?
Yes, that there should be no other, that the memoranda should not address any issues other than those raised.
No new issues,
Correct.
in other words, okay,
Correct.
okay.
I mean, I'll ask the board, is that your understanding? Is that what you?
If it's okay with councils, yes. All three councils are,
Excuse me for a
Concur.
moment.
Sure. Ms. Levin, you're good with that too?
Yeah.
All right. Levin.
Okay, your calendar pulled up.
Yeah.
Let's get our calendars out.
Yeah.
You all are so great at scheduling BZA.
Well, we pick a date and then make a motion.
If we're
So we'll see you
submitting,
back here next Wednesday?
if we're submitting concurrently,
All right, so
it would be helpful
Yeah.
to determine when a resumption date would be
Right.
scheduled.
Well, let me throw,
So neither of us is shortchanging
Understood.
ourselves.
let me throw a little monkey wrench into that, a little bit. That is that, the board would like to meet again very shortly, maybe next week if possible, so that it can meet in closed session and make a determination on the variance issue, so that you can then determine whether you are going to move forward with the O2 case or not, depending upon the outcome of that case. And so, I mean, we do not want to delay this any longer. And I think we have all the memoranda have been submitted.
On the variance.
On the variance,
case.
on the
Yes,
O3
I
case.
believe that's right.
I'd like to make a determination on that, so you can then make a determination to whether or not you're gonna move forward on the O2 case.
can we do the,
And-
that and this? in
Yeah, I
one
was gonna
night?
say, I don't, if it's, that may be too soon for this case to be determined by that.
To be memorized.
Maybe we can go to the following, but I think we need more time. We're
Okay.
gonna need more time to really digest the memoranda. These are complicated issues.
I understand what you're saying, and I appreciate your trying to work to get this all done.
Right.
When, arguably, would a hearing or a new hearing date on the O2 be scheduled? And when would a hearing resumption on this deliberation be scheduled?
Well, this is a
Could they be done as-
continuation, and the O3 is a continuation. And the notification, public notification requirements for an O2 hearing, now that's a new hearing.
That's right.
O2 would be a new hearing
That's correct.
if we proceed
After-
with that.
Sometime after
So
the
we have
date.
notification
Assuming
requirements,
that would take place, I mean, it may not,
Yeah.
depending upon the outcome of the variance case.
but these are continuations, so
That's
what,
correct.
I don't know, how much notification do we need on these?
We don't need any, like, obviously we have to post an agenda and do all those, that's just a normal, 72 hours in advance for, the continuation of O2, 2025
It's not a
O2.
continuation, but a.
No, O4. We're
That's
doing
gonna be
O-
a whole-
That's a new case.
Right, well, that's what I'm saying, that one would have to go through the same legal,
Yes.
Oh, the 25th of
advertising
February.
process.
But right now, we're talking about continuing O4 and O3.
We can pick whatever
They're
day
going
we
to
need
open
to
up the
pick.
variance.
We don't have long notification requirements for those.
No prolonged
Memo is
notification
gonna-
requirements, again, we gotta get an agenda posted.
All right, so
Once
if-
I have it all done next week.
We're gonna be back here next week on the variance.
I have an idea.
Okay.
We'd like to propose, and hopefully it won't blow up in all our faces.
no snowstorms.
Next Wednesday, we
Yeah.
could reconvene for determination on the variance.
The 11th.
Is that the 11th? Yes, it is the 11th.
Yep.
On the 13th, Ms. Levan, we can file the memos.
On this case.
In this case.
Friday, 13th.
Can we,
What's the
Friday
11th?
13th.
can we
Sure.
go to Monday the 16th?
Okay, I mean,
Well, that's President's Day, does that bother you?
it never has before. I don't see how it would.
Right,
I mean, I can wear,
Yeah.
I'll wear a stovepipe hat if you want.
So,
And could we do the resumption of O2, if we're gonna resume O2 on February
It's
25th.
not a resumption, let's be clear that that would require, when you're saying, that would require new advertising and all that, so it may be a little more, there may be a lengthier.
Whatever the verbiage, correct verbiage.
Okay, so real quickly, I think, if I can, real quickly. Next week, you meet on the Wednesday, the 11th, and you determine the variance. You're going to
03?
Yes.
I don't know the numbers, I'm just gonna say the
Yes.
variance, okay?
Yes,
And then Monday, the 16th, the memos are due on this appeal for Thrive.
For 04.
for both parties,
For both parties, it's due on the 16th.
right.
And then on Wednesday, the 25th, we reconvene.
We have another meeting.
25th is not.
Okay, how about the 26th?
We have a meeting that day.
What happened to 04?
That's what I'm saying.
He's trying to
I'm
set-
trying to set up the reconvening this hearing. The memos would have been in on the 16th, a week or so after that, maybe the 24th? Is the 24th, do you have a meeting?
That's a Tuesday.
That's a Tuesday.
The 4th would be,
That's-
the week,
that's
one
not
week
good for
from the
me.
25th
Sorry?
would be good for me.
That's not good for me. 25th would be okay, but,
Yeah,
25th's not good for the.
Yeah,
There's another
Oh.
town meeting.
yeah. If you go into the next week, the 4th would be.
well,
good for me.
I could make I'll have to do some shifting around, but I'll make the 24th work then.
That would be awesome.
Thank you.
All
And
right.
the 24th would be the resumption of the Thrive Parcel B
This is
hearing.
04.
Right,
No,
04, okay. And then we'll deal with 02 after we get the variance.
Well, on the next Wednesday night, the 11th, there will be a determination made on the variance case. We will go into closed session to discuss it, come out of closed session, the board will take a vote on, that's the 04 case. Sorry, 03, the variance.
variance is 03.
Right. The memorandum on the 04 case will be submitted by the COB on the 16th of February.
They'll be submitted by or received by?
Well, submit, they'll be,
It's the same.
they'll be given to the board
Okay.
by then.
Because we're gonna put this in a motion here.
Right. And then, I guess at that point, we have to determine then the next date, we're talking about the 24th, would be the night at which the board would go into closed session to discuss the 04 case,
That'll be the continuation of 04.
Correct. and then come out of closed session, presumably take a vote that evening, on the 24th. And then the 02 case, we'll leave in abeyance for a moment, we'll figure that out after
Okay.
the 03 and go from there.
All right.
Does that make sense?
Not really, but I mean, it's the best.
All right, well, let me make a motion and listen carefully.
Mr. Chairman, real quick, sorry.
Yes, sir.
6 o'clock, okay?
Oh, yeah.
For which one?
Both.
Yes.
All of them.
All three?
Yeah.
Oh, yeah,
okay?
it would be both, I'm sorry.
Can I selfishly request earlier for the 11th? If not, it's totally fine, but
Yeah, I can't make it any earlier on the 11th.
Are you, is earlier meaning the 6 o'clock or 7?
No, he's saying earlier than 6.
We started
yeah,
with the
again,
presumption
just selfishly,
No,
if
I'm
it was possible, but if
Coming
not,
out of the dentist appointment on the 11th, so I'd rate
Sure.
just keep it at 6. So I'm not talking like this, you know?
it might still be like that.
If you're in pain, it could be really problematic.
All right, let me make a motion then. All right. I move that we continue this session, this case, 2025-04, on February the 24th at 6 p.m., that we meet to conclude, if possible, the variances case number 2025-03, on February the 11th at 6 p.m., and that all memoranda for case 2025-04 be submitted and filed by February the 16th.
Okay.
Any seconds?
Second.
Second, all in favor? All right, that's passed.
Move to adjourn.
Got that, Carrie?
Yes, sir.
All right.
Thank you very much.
All right, gentlemen, then without any further ado, I will adjourn this meeting. Thank you all very much.
Thank you.
Gentlemen, before you go, do you all have?